Good evening. This is the Tuesday, August 22nd, 2023 regular meeting of the Columbus Borough Planning Board. This meeting is called pursuant to the provisions of the Open Public Meetings Act with adequate and electronic notice of this meeting has been provided by way of publication in the Hunterdon County Courier News newspapers on or about January 18th, 19th, 2023. In addition, notice of the meeting was posted on the door of the Borough of Columbus Municipal Building located here, 38 Park Avenue, and any handicap accessible entrances there too. Posted on the municipal website, provided to the municipal clerk, and distributed to all persons, if any, requesting copies of same. This meeting is being recorded with both audio and video and may be rebroadcast. This meeting is a judicial proceeding. Any questions or comments must be limited to the issues that are relevant to what the court may legally consider in reaching a decision, and decorum appropriate to a judicial hearing must be maintained at all times. Can everyone please rise as you're able to flag salutes. Pledge allegiance to the flag
of the United States of America, the republic for which it stands,
with liberty and justice for all.
Mayor Carroll here. Councilwoman Engelhardt here. Mr. Campion
here.
Here.
Mr. Levitt
Here.
Mr. Cook.
Here.
Ms. Giffen is excused. Ms. Weitzman
Here.
Mr. Hill.
Here.
Mr. Semino. Mr. Eckel.
Here.
Mr. Schob.
Here.
Ms. Kaczynski.
Here.
Clerico.
Here.
Ms. McManus. Here. Mr. Campion.
Here. Before we get started with item one, public comments, just a note that our board's attorney is participating remotely. Carrie is there. So I'm going to ask everyone, applicants, public, professionals, board members, make sure you're leaning into and Jim, other than that, just so that we should do that as all the time, but just to make sure Kara has a complete and accurate of what's going on. So
I don't know.
Okay, item one on the agenda, as always, it's time for public comments. If any members of the public wish to speak on an item not currently in front of the board, please raise your hand. Seeing none, we'll move on. Mayor comments?
Thank you.
Thank you, Mayor. Council comments? Susan?
I do not have anything. Thank you.
Excellent. HBC comments, Dennis.
Hi, three items regarding 37 Mine Street, new development, also known as Central Station LLC. The HPC will be providing the planning board feedback before the public hearing on that one. Also, the HPC is drafting a memo to the planning board on the expansion of the historic district to reflect what was recommended back in 2019. And then the HPC is addressing new issues raised by SHPO regarding being a historic certified local government. So more to follow on that, but those are the three items we had.
Thank you, Dennis. Item 5 on our agenda this evening is approval of minutes from the August 8th, 2023 regular meeting. Those minutes were previously circulated by email. Can I get a motion and second on the minutes?
Engelhardt moves.
Is there any discussion, corrections, or clarifications for the minutes?
Ms. Engelhardt? Yes. Mr. Cook?
Yes.
Mayor Carroll? Yes. Mr. Campion?
Yes.
Joshua?
Yes.
Mr. Levitt?
Yes.
Ms. Weitzman?
Yes.
Mr. Hill?
Mr. Hill does not appear to be in front of his computer, so let's call the next.
Mr. Semino?
Yes.
Mr. Eckel?
Yes.
Okay, thank you very much.
Okay. Item 6 on the agenda is a request for return of escrow for Countryside Plaza Block 35, Lot 32. That's on Stangle Road. That project was the expansion of Lone Eagle, if folks remember that. So we had circulated from the professionals.
Right, all of the professionals and also the Rob Martucci had also given there's no outstanding invoices and nothing.
For the record, I will recuse from the vote. At the time, I was not on the board. In fact, I was the planner for the applicant in question, so I'm going to not vote. Any discussion, questions?
And this would just be a motion, I believe, and then it goes to council for their final approval and a resolution.
So can I get a motion? I'm sorry.
I'm sorry.
Good.
How is Rob Martucci involved in this?
He was at the time employed by Van Cleef, and he did the inspections at that time.
Okay, so I'll make a motion that we're using the escrow for Countryside Plaza, block 35, block 32.
Mr. Cook,
Yes.
Mr. Semina,
Yes.
Councilwoman Engelhardt,
Yes.
Mr. Campion,
Yes.
Mr. Levitt, Ms. Weitzman,
Yes.
Mr. Hill,
Jim, you're muted.
talking, but he was not.
Jim, you're muted. We can't hear you if you're talking.
You went, okay, sorry. So I have to recuse myself because I had to take a call while you're having a discussion.
Mr. Eckel,
Yes.
Mr. Show.
Yes.
Thank you. Did I miss you? My sincere apologies. Mayor Carroll, yeah.
I threw her off with my recusal and I just got reworded on that.
I guess
It's because I wasn't here last year.
I think it's the heat.
That's it. People blaming on you. All right, item number 7 on the agenda this evening. Upon the recommendation of our board, Borough Council introduced a set of ordinance changes at their previous meeting, which then come to us for a consistency review with our master plan. So Beth, here's the easy question. Is there any change from what council introduced on first reading to what we sent them?
No, not that I'm aware of.
Okay. All right, we'll do it. We'll put this all on the record. So can you report on consistency?
Yes, I'd be happy to. So there are a handful of ordinances that are before the planning board that amend a variety of issues from zoning districts like the BAS district, TC district, to more administrative items like updating definitions for the borough. And in each of these instances, the changes came from the planning board's subcommittee, which was put together in order to implement the master plan. As a result of that, the ordinances follow the recommendations of the master plan. So I view each of these various ordinances as being consistent with the master plan and in fact are intended to implement the recommendations there.
Kara, can we do it all together or should we do that one ordinance at a time?
Well, the only concern I would have is if anybody has any issue with voting on one versus the other have here.
Okay, you're,
Incorporate. Yeah, can you hear me?
we can hear you breaking up a little. You
Is
might
that
have,
better?
yeah, you might have to turn your video off. This is the joys
I
of,
was thinking that too. Yeah, I'm sorry. Okay, so I did do a draft resolution that isn't complete because we don't know if anybody has any recommendations on any of the resolutions to report back to council. But I have no problem if everyone is comfortable voting on each one. I have no problem doing one vote with and one discussion with everything together, and then I can incorporate it into the one resolution. But if anyone does have any concerns with voting on one versus the other, then we should separate.
okay, so I'll turn to the board. Is there any discussion or any recommendations or suggestions we want to make to the governing body? I'm not seeing anything. Is there any objection to handling these all together?
No, as long as Kara says that's okay. I mean, you know what they all are.
Yep.
Everybody's willing to go for all.
Right, right. Okay, so, then I would need a motion to find that all of the ordinances that have been sent are consistent with the borough's master plan, and that we have no additional comments or recommendations to send on to the governing body.
Yeah, I like to make the motion, but Beth, do you have the specific ordinances?
Sure, yeah, I have the email from.
Yeah, just to
So I can read them by ordinance number, is that what you're interested in?
yeah, because I'll make the motion. I just want to make it specific for the record.
Sorry, agenda just says next.
Yeah,
Oh, okay. It is ordinance number is 2023-23, 2023-25, 2023-24, 2023-26, and 2023-27. So 5 ordinances in all.
and could you humor me with just a title for each? Sorry, I couldn't find the email.
That's okay. So 2023-23 is an ordinance, I think that it's ordinance amending the zoning map. But more specifically, what this does is this addresses a variety of zoning map issues, including expanding the TC district, eliminating the PO district, those changes.
Okay,
We also have 2023-24, that is the ordinance entitled Village Artisan District, VAS District. 2023-25 is an ordinance entitled Public Arts Committee, creation of that committee. 2023-26 is an ordinance amending section 1201 definitions. And then the last item is 2023-27, and this is another district that amends the zoning map addressing creation of the TC district.
But I
Or
thought,
amend-
Public Arts Committee should
I
not
was gonna
be.
say, the planning board did not send the Public Arts Committee to,
Right,
we worked on it, the subcommittee
Was that
selected it, it was introduced, absolutely it was. But it was sent, remember you said you wanted Chris Corsini to do
Yeah.
it through the council?
And I believe you did.
So he did.
Yeah.
He blessed everything, he didn't make a change.
It came, I guess a better, more nuanced is, the Public Arts Committee ordinance, was heard by the Master Plan Subcommittee, but not specifically.
it didn't come to this board for discussion.
Correct.
Okay, so I would say,
But it did come over,
I think it was.
it was,
not a big draft.
it was suggested in the 2010-2014 master plan, but it was, so I don't know, but it, and it stemmed from the subcommittee, so I don't know if that means anything.
all,
No, because it's not a planning board matter.
the only,
No, it's not zoning ordinance.
it's not a zoning ordinance, but but when I read it, it said that one of the members of the committee would be a member of the planning board.
Right.
So the question is that ordinance require a consistency determination?
I tend to think no, because it's not a zoning ordinance or a land use ordinance, but I do think that I should refer to our esteemed attorney.
Right, well, Chris Corsini did not think so.
Kara, does that one require us to do a consistency review?
I agree with that, that since it's not a portion of the zoning ordinance, we technically, according to the land use law, don't have to. Since there is reference to the board, certainly the board can make a recommendation back if they're in approval of it, but I would say from a requirement standpoint, it's not required to be found consistent with the master.
Okay, so that's ordinance 25. And we don't find it inconsistent, but it's not necessarily required, right?
Correct.
Okay.
Correct.
I'm sorry, could you just go, the first and the 5th, even though we're not voting on the Arts Council, the 1st and the 5th were both related to the zoning map. Could you repeat what the last zoning map?
Yeah.
change was?
27 is the one you're.
Yeah,
I just
27.
don't remember the numbers off the top of my head.
You had given us a brief summary.
So 2023-23 is the ordinance which addresses a variety of zone districts, including amendment of the TC district. And Eileen, I have to say, I'm sorry to say this, I didn't double check the numbers, but I think these are repeats. 2023.
Yeah, I'm looking at it too, and it does, the title's different.
They both, they amend, I'm sorry, Kara, they amend a variety of zone district boundaries and then fundamentally amend the TC district.
23, 27.
23 and 27. So I think a more accurate representation of what is before the board this evening would be ordinances 2023 or 27. They appear to be the same. We also have 26, which is the definitions ordinance, 24, which is the VAS district, and then 25 is is included in the email, but that is public arts ordinance that doesn't require planning board review.
So I would say the motion would be that the board is making a finding that ordinance 2023-23, 24, and 26 are consistent. 24 comes out, 27 is the due. I think that's what Beth just said, but that's the motion.
That is what Beth said, is that? That's the motion, Todd, that's what you're making?
Yeah, yep, I'll move that.
Do I have a second? Okay. Any further discussion or questions?
My only question is, do we have to do anything other than, so our recommendation from the Arts Council Committee, whatever we said, is there? I mean, the council has that. I know you guys didn't have anything to report on, but did you talk about it? Did you? No?
It never came here. They never saw it.
Oh,
We never brought
It
it.
went from Beth to me to Chris Corsini,
okay.
and then it went directly to council and Chris said, I'm making no changes. You guys never saw it.
It never came here. We didn't have a discussion on it. That said, as Susan pointed out, this is something that has been in our planning documents for the last 15 years.
This is a recommendation for the council to act on it, which
Yeah.
we are, then it's exciting.
Yeah, so it certainly means a consistency with planning documents, but it doesn't explicitly require our.
Right.
So, okay, so Susan, you can say that, yay, but finally 15 years later, we're moving on it, but it's not, doesn't require us to do anything, I don't think. From what I'm hearing from Kara. Okay. Other questions or discussion?
And 27 will just get stricken.
Correct. Yeah, it was a duplicate to 23. Yeah, I'm sorry. I was trying to run through them quickly.
That's why I asked, because it didn't seem like. It was-
No, I appreciate that. Thank you for asking me to.
So Susan, that might be it's an administrative thing. It doesn't necessarily have to go with the resolution that Kara's working on, but just to make sure that you're only gonna vote on it once. Okay,
The second was Trent.
Trent, yeah. Any other discussion or questions? Okay,
Mr. Cook,
Yes.
Mr. Levitt,
yes.
Mayor Carroll,
Yes.
Councilwoman Engelhardt,
Yes.
Mr. Campion,
Yes.
Mr. Joshua,
Yes,
Ms. Weitzman,
yes,
Mr. Hill,
Yes.
Mr. Semino. Thank you.
thank you. All right, item 8 on the agenda this evening is a completeness determination for Flemington Realty Partners LLC application 2023-04, block 39, lot 6, excuse me, 78 Church Street. This is a minor site plan application. I'm going to ask if you can grab a seat up there, and when I say promote to panelist on that laptop, if you wouldn't mind clicking yes. Sure. That way everyone remotely can see. You don't have to worry, just turn on the camera on that one. But you don't have to unmute it because you'll use the other microphone.
When is the public hearing for the council on those orders?
The 11th.
work with Kara to get that resolution to.
And if you wouldn't mind, like, you can move the laptop, just so that folks, yeah, perfect. There you go. Thanks.
Good evening, Chairman and members of the board. My name is Danielle Kingback. I'm an attorney at Prime and Tavell. I'm here on behalf of the applicant Flemington Realty Partners 2 LLC on their application for a minor site plan on block 39, lot 6, also known as 78 Church Street, here for a completeness hearing. We're in receipt of the board engineer's completeness review memo dated August 14, 2023. Wherein he recommends the board grant a number of waivers. And he lists a few items that are incomplete. With respect to those items listed, I know for number 11, we did submit a letter with our application. I have a few extra copies that note the taxes and utilities are both current. It's just not on the form that the borough issues, but we can provide that before we're scheduled for any formal hearing. And with respect to number 50, I have our engineer, Matthew Seckler from Stonefield Engineering here, who can provide more information on that. With respect to the remaining items, we're requesting to be deemed conditionally complete, and we'll provide them in advance of hearings, and we can answer any further questions of the board or its professionals.
Great. Bob, if you could go over, pull the microphone closer just for clarity. Yeah.
Yes, the applicant made a revised submission today, actually. I don't think they brought additional copies of that was filed with the board itself. But they did file revised plans. It has a supplemental sheet. They did file a revised architectural plan, floor plan of the building that, as I understand it, shows the composite building with the two different uses. But there is some additional information that came in this morning. Just going through the report, the item 4, the issue with the person responsible for preparing the plan is now identified on the new submission. The issue with the track boundary, they added a new sheet that actually just shows this property is condominium. There's 3 buildings on it. It's one property with a good condo. This is an application for one of the condo units. The plan they submitted showed the meets and bounds information for that condo unit and the adjoining pertinent easements associated with that particular unit. Technically doesn't show the boundary of the property, but I think for the purposes of completeness, we could accept that. As the attorney just said, the submission form on taxes does refer to utilities as well. So that was address item 11. Again, an item, the survey, the meets and bounds information, again, is for the condo unit, but not the property. So you could either say it's complete, or we can just grant a temporary waiver for the property. Should, in the event of reviewing this application, should we need to know more information about the property itself, we could certainly require it. So you may want to consider that a temporary waiver. There is a waiver on item 20. There's an owner certification associated with the application, but it doesn't appear on the plan itself. So I had suggested, and the applicant is requesting the waiver from that particular item, it's item 20. The existing easements, those are items 27, 28, and 42. They are reflected on the new sheet, or at least the easements associated with the condo unit are. So we can again consider those complete. Item 36 and 43 was I was suggesting the applicant request a waiver from that. That was environmentally sensitive features. Item 50 deals with the utility infrastructure. It wasn't clear to me in the applicant's response on this in terms of what they're doing internal to the building, if that's going to require any additional plumbing. The response back from the engineer was that it wouldn't. I think we would probably ask for a filing of the phase 1 application with the borough water and sewer. More than most likely, it doesn't have any impact, but again, that's not the board's decision. That goes with the utility. So I think we do that in a temporary waiver. The borough has a form for filing with the water and sewer, so just so they're aware of the application, and if they have anything to say, they'll advise the board on it. So I put that in the form of a temporary waiver. Lighting plans are not proposing anything, they're really showing the same thing. Again, I would recommend that you put that in the form of the temporary waiver. In the event lighting comes up as an issue in the project, Landscaping, they're asking for a waiver on it. Again, they're not proposing anything on the site. And the issue of signs they're indicating, sure, that's correct. Yeah, and the issue of signs, they're indicating that they're going to be doing something with signs. They're going to comply with the ordinance, but they are not in a position right now to show it to us. So our checklist does require showing signs, but again, I defer to the board on that. We could consider that a waiver. That was item 61. They asked for a waiver on showing site triangles. Again, this is a developed site, so it's recommending that. The architectural plan, they now have a plan for the whole building, so that item would be complete. And sorry, item 69 is also on signs. So again, that could be in the category of the temporary waiver. So based on the updates of what I had in the report, you'd be, if you're in agreement, you'd be doing waivers on checklist items 59, 61, 62. You'd be doing waivers on checklist items 20, 36, and 43. You'd be doing temporary waivers on checklist items. These are not in order: 58, 50, 15, and 19. And the remaining items that I had said were incomplete, you can now consider complete. So if you take the action on the 3 actions on waivers, you would have a complete application.
Ken, please.
I just want to ask a question regarding, moving off the sewer water. It seems like the usage of what's being proposed is more, I mean, Rite Aid has 6 employees in there, right? In that great big building. And I don't think public overly used restrooms in there. So, you know, I do think that we need to take that into consideration, that this is a more intense use. I mean, the bank side might not be, but I don't know what a training center looks like.
If they file the application with DPW for water and sewer, they would, Ken would look at it, Josh would look at it, they would look at what they're proposing and they would report back that it's either it's additional capacity, it's whatever, they report back and whatever their conclusions are. Normally the board relies on whatever they.
So your recommendation is a temporary waiver on 50 so that we can
They should have filed the
codify the application, and when we get to the hearing, if they need to do anything in response to water and sewer, then we would that would become part of the hearing.
They're not proposing anything to do anything with utility. Actually, they're not even showing us the utility connections for the building against the developed site. It's more of a change in use application. It becomes a site plan, mainly from the standpoint that they are doing something outside with the ATM units, where they're installing ATM units that weren't there on the drive-through lanes that the bank was using. That another way that the pharmacy was using.
Other questions for Bob?
So it being a change of use, Bob, if the planning board has issues with outside lighting or outside plantings or landscaping, we have an opportunity to fix those problems.
I would defer to Kara, but I would say so, sure. It's a site plan application, so.
But if
And
we
we're granting waivers or temporary waivers right now, that's for completeness. Certainly, as you're going through with the site plan, you can ask the applicant to submit some more detailed information because you feel that's necessary for you to rule on the site plan. All you're just saying right now is based on what they've represented, anything else to deem it complete. But at any time during the hearing, if you need more, you advise the applicant of that.
I believe the beginning of your statement was you were breaking out for that these are only, they are temporary waivers until the applicant is in front of us. Talking about the application, we're not waiving our right to landscaping and lighting inside of everything else. This was just a temporary waiver until.
Or we're not, it's a development checklist.
Yeah, it's completeness. Even if you waived them provided in the site plan right now, what you're saying is you don't need to see it right now to start the hearing. If, however, during the hearing, things come up where we think the lighting is insufficient, we want to see some landscaping, we want to make it a condition of approval, we want to see it now, you're not waiving any right to that by granting these waivers temporary or otherwise.
Thank you.
Any other questions? Okay, so what I'm looking for is a motion
So I'll
to
make
deem
the-
them complete.
I'll make a motion to completely with waivers for checklist items 59, 61, and 62.
10, 20, 36, 43.
Right, and also include the waivers for 20, 36, and 43, temporary waivers for 58, 50, and 19,
And 15.
and the 15, and 15. That covers.
That was that's the list, right? That's what I've got, Bob.
Yes.
All right,
The rest is all complete.
everything else. Is there a second?
Don't move, Jim.
Give it to Jim. Any further questions or discussion?
Now, thanks, Bob.
All right, call the roll, please.
Mr. Cook,
Yes.
Mr. Hill,
Yes,
Mayor Carroll.
Yes.
Councilwoman Engelhardt,
Yes.
Mr. Campion,
no,
Joshna,
Yes.
Mr. Levitt, Ms. Weitzman,
Yes.
Mr. Semino.
Okay, thank you. So, a couple things. One, water and sewer, make sure that gets taken care of. You heard that there might be some discussion about landscaping and lighting, so maybe be ready to address those at the hearing. Usually we try to think about when we can schedule. If you're ready to have that conversation. If not, we can do that at another point, but it's a minor, so it's usually not, the review is not as involved, but what's our calendar look like?
Well, September 12th is our next meeting, and that has 2 public hearings already scheduled.
So that's not gonna work.
No,
Okay.
and that's 3 weeks away. I don't know if, since it's minor, does it need a notice to be made, Karen?
We usually do anyway.
You do any?
Yes.
Next meeting in September is actually the 19th.
Is so,
And then it's the 3rd.
and then October 3rd,
Yeah, September and October, we can start to get into holidays.
Labor Day.
Okay.
and such.
Oh, Mr. Suckler. Okay. Then we'll do,
So tentatively, then
You wanna go?
yeah, we'll
sooner
shoot
later?
for the 19th, and if something comes up or it isn't ready, we'll deal with it. before
Okay.
then. Okay,
Okay, so tentatively scheduled for September 19th.
correct.
All right.
thank you.
We don't have a meeting.
We do not have a meeting on the
No.
26th. Council took the Tuesday because.
Yeah.
Yes, because Monday is. All right, thank you. Item number 9 on the agenda this evening is another completeness determination, Central Station LLC, application 2023-05, block 34, lot 7, property at 39 Mine Street. For those who've been in town, this is the old Burkett's site. Major preliminary and final site plan application with use and bulk variances and waivers.
Mr. Chairman, since this is a use, the mayor and council.
Since this is a use, I'll say that Kara didn't quite cut through, but because there's a use waiver, we will excuse the class 1 and class 3 members. Y'all also, you here in Spice Factory or you out for Spice Factory?
No.
You're here from Spice Factory. So before we let the 2 of you go for the evening, this will be nice about it because it's hot in here. Is there anything under chair items that you want us to bring up?
No, but I did have something under bills. It's very minor.
Okay,
Bob, your invoices should be written to the new, clerk, not the former.
okay, so that's easy. Anything to add? You're good?
No, which is the temperature will drop like 10 degrees, but you politicians leave the room.
The only thing under chair for one of you is, can we get an update of our areas need of redevelopment?
There is still exactly the same.
Well, that can't be exactly.
Discussions are happening and,
So for a month and a half, nothing's changed.
things are happening. There are discussions. And when it needs to come here, it'll come here.
Well, thank you for the transparency.
It's all under
All under lock.
it's all under
All under
negotiations.
lock and key.
Well, I didn't hear you say that about the former mayor. It was nothing up here, except to you as chair, not to the entire planning board. So
Just looking for transparency.
if I could share it, I would share it. And
Thank
it is currently under negotiation.
Oh, that's- yeah.
Mr. Grunberg,
Evening, Mr. Chairman.
evening.
Stephen Grunberg on behalf of the applicant Central Station LLC. As Chair said, this is a Bill Burkett's supply property, and we're excited to essentially redevelop that property, even though it's not a redevelopment plan, into there's presently 4 buildings on site, and we plan on putting 2 buildings on the site. The first building will have the permitted commercial and retail businesses on the first floor and 4 residential units on the second and third floors. And the other building will have a multifamily residential building consisting of 7 3-story residential units. Mr. Clerico asked in his report whether those units were planned to be rental apartments or condo, and they're planned to become. They're going to be owned units and not rentals. Mr. Clerico did a very comprehensive completeness review correspondence, and I think we have addressed all of those most recently this afternoon, but I think we've addressed all of the comments that were contained in his completeness review, other than the things that we either requested waivers for, or he recommended that waivers be granted for. So I'm happy, I have Mr. Rupnarain here to address any comments, but we did submit revised plans to tidy up some of those things that he indicated were incomplete.
Okay, so Bob, if you could
Sure.
just go through, I guess we're kind of already on like page 3 of your review letter.
Well, the applicant, Mr. Grunberg indicated the applicant did submit well, they submitted a number of things. They submitted electronically a copy of the revised plans. I'm gonna need that. I'm gonna need a hard copy of that. They did submit a copy of an off-site easement, which Steve had submitted, I think later last week or sometime since we wrote the report, subsequent to writing our report. And they are asking for a waiver of an environmental impact statement, but they did submit electronically a copy of the phase 1 study that was done for the property itself. Actually, the essential elements of that really are just the report and some site photographs. The rest of the report, which is voluminous, it's really not of any real consequence, obviously, anything. But they still need a waiver. They're still asking for a waiver of environmental statement. So going through my report, which does start on page 3. They did supply the first 3 items, which are relating to the offsite easement. The next 4 items are they were incomplete. The stuff came in this afternoon at 4 o'clock or 4:30. I really haven't had a chance to review it. There was an email from the applicant's engineer, Mr. Rupnarain, indicating how they have addressed all those items. They're more administrative in nature than anything. I can't sit here tonight and tell you that they have addressed those. The representation is they have, and they are.
This is items 4, 25, and 30.
4, 25, 30, 36, and 44, 53, and 49. He's indicating the information has been incorporated into their revised plans. What the board has done in the past when they don't have the information, sometimes the board has said that they would deem it incomplete, but they said upon submission of those items, it will become complete and they'll consider scheduling a hearing. Again, that's administratively up to the board. The representation is that the stuff did come in. I haven't had a chance to look at it. The representation is that, as indicated in the email from Mr. Rupnarain, that information he's telling me where that's been incorporated into the plan and how it's been addressed.
If I might,
Yeah,
just on that issue, we would request that not be deemed administrative incomplete, but if you have a question about it, that grant a waiver for completeness purposes only, because these items are kind of ministerial. It's the name of the surveyor, the width of Bennell Street, the list of required permits. All of these are just administrative items that have been provided. Mr. Rupnarain can indicate this, but we asked for, or I think Mr. Clerico recommended a partial waiver with respect to determining topo 200 feet from the property, but we went out and did as he requested in terms of the trees within a certain distance of the property. So, all of that information is kind of, ministerial as opposed to substantive, and we would request just to be able to be deemed complete, and just so that he can confirm that, yes, the name of the surveyor is on the plan.
Can we call that a temporary waiver? Is that something that's?
There's a lot of ways you could handle it. I mean, you could, the representation is they provided the information. I will eventually confirm whether they did or they didn't.
Right.
So if you want to put it in the category of a temporary waiver, just because we really don't have time to look at this.
I mean, the temporary waiver, then, and if it's not there before the hearing starts, then
Yeah.
I mean, what I'm hearing then is if he checks it and it's there, we're done. If he checks it and it's not there, it'll be satisfied before the hearing begins.
Yes.
So I think that.
Yeah, and Mr. Gruber indicated that a number of these things are administrative. There are some that are helpful information, providing it and clarity. That was kind of critical. If that's not there when we go to do a review, we're going to be basically saying we can't review this because.
Okay, so then if that's the case, then if it's not there when the review needs to happen, then we will not be able to proceed with the hearing. I mean, that's
Understood.
understood. Okay. So I think we can put that as a temporary waiver on those items there. Okay.
Yeah, that would be an appropriate way, you know, that'd be one way to accommodate. You still are though being asked to do a number of waivers here. So I would defer to Jay. I think you wrote a report saying that Jay wrote a report that the board should have saying that he didn't think the traffic study was necessary.
So that's 68. Yep.
Yeah. So if I did my accounting here correctly, your temporary waivers would be for the items that have been, the applicant's representation has been submitted, which are 4, 25, 30, 36, 44, 53, and 49. I did also point out, and I believe they've done it in the interim, that they needed to file a water and sewer application. That came in, I'm not sure if that came in today or when that came in, but they an application for filing for water and sewer review that did come in. And the so your waivers would, your permanent waivers would be for 37 and 41. I'm just reading from our report now. Also permanent waivers for 38, 39, and 40. Temporary waivers for item 65 plus the ones I just read earlier. I was deferring to the board. Why is that deferring to the board on 61 and 60? What was that?
Those are just signed.
Oh, signed.
That would be the same waiver request that was just made in that other application.
And Jay had indicated on 68 that we could do a waiver on that as well. Waiver on 52.
52 is the EIS.
Oh, the EI, again, that's like deferred. You didn't get an environmental impact statement. You did get a, if you want to hear some testimony from the applicant, also why they're asking for the waiver, but
I think it's honest now that I'm looking at all this and the stuff that they've said that they've given us that we're going to confirm under a temporary waiver. The only substantive item then is the environmental impact.
Yeah, we provided, as Mr. Clerico had indicated, that we should be required to present the phase 1 assessment as part of the submission. We provided the phase 1 assessment, and I hand delivered it myself. It's a box of the phase 1 assessment of the property. So I think that more than satisfies the intent of the environmental impact statement. And we supplied that to Ms. Parks digitally as well. So
it's, and the property's in the middle of town. There's no map environmental features here. There's no floodplain.
Right, it's not in a floodplain, it's not in a flood hazard area, it's not in a wellhead protection area, it's not a known contaminated site.
No wetlands.
No wetlands, like we could run through all that, right?
Right.
So, but it was a site that for a very long time had an appliance shop on there, and there might have been stuff, but all of that would be captured on phase 1.
I would think so. Again, I haven't read the document, but again, what I suggested at a minimum, they should file that. So they did follow my recommendation and file that.
So it sounds like they'd at least met the minimum that you suggested.
And if there's an issue that arises during the public hearing, that if there's a question that arises, we can always address that at that time. We're asking for,
You're asking for a waiver from that requirement.
correct.
Having submitted that, you're asking for a waiver from EIS. I want to hear what the folks on the board have to say, but if the environmental commission will absolutely provide their review letter, as is their right to do so, and that'll come in before. We'll encourage them to do it with enough time before, so that it's not like the day of the hearing, so that y'all be able to have testimony ready if need be. And, so we'll make sure that they would get phase one, because it's digital. We don't need to give them a box, but they have additional questions, and so if their review letter comes in with sufficient time that you can provide it to the board's professionals ahead of the hearing, I would encourage you to do so, or at a minimum, just be ready to put that on the record when it gets.
Understood.
Mr. Chairman, quick question, just for my notes. Did we get a copy of the deed and that information requested in 319 and 28?
Yes, they did provide.
We did, okay.
All right, so it's, did you like all those numbers?
Yeah.
Okay, so it sounds like there are requests for permanent waivers for 37, 41, 38, 39, 40, 61 and 69 are on signage and 68 on traffic. And on 52, which is the EIS, a temporary waiver for 65, 4, 25, 30, 36,
53,
53,
49.
54. All right. Those are those other ones on temporary waivers, and then deem it complete. That's what I'm hearing here. Someone check the math, make sure.
That's what I had as well. I was ready to make that motion.
Okay, so
Do I need to repeat it? I could.
Yeah, please.
Sure. Temporary waiver, Bob, if you follow along, temporary waiver on items 4, 25, 30, 36, 53, 49, and 65.
44 also.
Oh, and 44. Sorry.
Yep.
Permanent waiver for 37, 41, 38, 39, and 40. And 68, 69, and 61, which deal with traffic and signage, but fully understanding that the board will want to see signage and discuss traffic. I'm assuming a lot in the site. And then a waiver for number 52, which is environmental.
I didn't hear you say 3 and 28 and 19 for temporary waivers.
Were they?
Didn't say that. That way you didn't hear.
That's because you provided.
you
Okay.
provided
Yeah.
3, 19, and 28.
Okay,
Yes.
then I provided.
Okay, yes, that's what we got. All right, so as Todd moves that, is there a second? Second, Levin, is there any further discussion or question on deeming the application complete subject to those aforementioned permanent and temporary waivers?
I just have one quick question about what was provided. It wasn't in the EIS, but what was it that you said?
Any other questions?
Mr. Cook,
Yes.
Mr. Levitt,
Yes.
Mr. Campion,
No.
Mr. Dasha,
Yes.
Ms. Weitzman,
Yeah.
Mr. Hill,
Yes.
Mr. Semina.
Yeah.
Thank you.
Thank you very much. I've got my trusty calendar.
Yes, so again, wanting to find if we could schedule, as you just heard, we have two, and you're well aware, we have two public hearings on the calendar for September 12th. We have now one scheduled tentatively for the 19th,
Right.
and then we have October 3rd is the meeting after that.
For the record, I know Wordsville was on for the 12th. What's the other one?
13 Brown.
13 Brown.
That's
a strike route.
Oh, good.
So that's that one. And then on the The other one is,
78 Church.
70 Church, just for, that's the one that's on the 19th, so.
Well, I'm gonna be here on the twelfth. That doesn't work possibly.
With two other hearings, I do not think that's gonna be, that's possible. The other thing is because of the EIS, we need to make sure that the environmental commission has a chance to meet there. I want them to be able to have at least a chance to go through phase one.
This is a major site, there's a.
It's a major site,
amount of
we need-
information everything.
We need some more time in that.
Also,
Yeah. Yeah, so I mean, we could give us, yeah. So the 19th is possible and as well, but I think that's pushing it, and I think October 3rd would be a better fit.
October 3rd. October 3rd. October 3rd.
October 3rd. All right, and because this is a use application, obviously, we want to make sure that as many of our board members are able to participate who aren't otherwise recused. So,
I'm glad it's the third, but I'm not here.
there you go. All right, I think we're there. All right, anything else? We're good?
Good.
Good, all right, thank you.
Thank you.
All right, item 10 on our agenda this evening is the continuation of the public hearing for ESV Flemington Apartments LLC, Block 39, lots 3 and 4, 70 Church Street, continued from April 25th, May 9th, and June 27th. Use variance application and related site plan, and this is otherwise known as Spiceway.
Good evening, Mr. Chairman. Stephen Groenberg on behalf of the applicant BSD Flemington Apartments. This is a continuation of our public hearing in which we amended our application to provide for a revised plan. And you will recall we had extensive input and concern raised by the board, but particularly with respect to the architectural of building 3. And in the interim, the tenant Regis has decided that they are no longer going to be a tenant. And they provided us with the opportunity, as discussed at the last public hearing, for us to revise our plan to reduce the size and scope of the 5th floor of that building, step it back as the board had indicated in terms of their concern, and to include the revision of the 2 buildings to allow for amenities to be in the 1st floor of the 1 building, which triggers use variance relief. We think this is a better plan, not only for the applicant, but for the borough. It's scaled down the scope of that building, but more importantly, we took a lot of effort to address the concerns of the board with respect to the architectural features of the new building. And I don't get a vote, but I think that the new building looks really, really nice in terms of the building rendering, in terms of what the board had indicated was their concerns in trying to map the existing Spice Factory building that you had spent a lot of time in the past working with that applicant to come up with a plan that was appealing to the board. We made an effort to try and match that existing approval because we weren't part of that process originally. My client wasn't part of that process. So this evening, we provided you notice of hearing, and I provided that in advance to provide the public notice of our revised and amended application. We have your board's professionals reports, which we appreciate. And I've got 3 witnesses this evening. I have Eli Yanay, who you've already heard from. I just want to have him come and testify again about the revised plan and the Regis situation, because I know that had raised an issue with some zoning permit application or something that was done there. But Mr. Yanay is the principal of the owner of the property and can set that straight. And then I have Alan Zimbler to take you through the architectural changes that we presented. And then Mr. Nusser will testify as to the revised plan. And we've already touched on the planning testimony in detail. He might highlight some things, but I think we've presented a lot of testimony both on engineering and planning. We're really going to just talk about what the changes are.
Okay, so Kara, I need to ask, did we reopen the public hearing at the last hearing? Did we vote?
Yep.
We did, so we do not need to do that again. I didn't remember if we did that or not. Okay, so please call your next witness.
Good day, please come forward.
The only thing, why don't we swear, let's just re-swear everybody in. I believe all three already testified, but let's just get everybody back on the record, swear them in and start the testimony.
You're all, you can stay where you are because you can be seen on the other camera, so just, you could stand, Kara, go ahead.
And our board professionals as well. You swear that you're about to give this board the truth, the whole truth, and nothing but the truth.
I do.
Okay. Forward.
Why don't you refresh the board as to your position with BSD Flemington Apartments?
Can I ask that you literally move the microphone just to the, like, push it around to the other side of the laptop? Please go around the back. Us to make sure we're perfect.
Why don't you tell the board, refresh the board as to your position with BSD Flemington Apartments?
Sure. Good evening. I am the CEO of BSD Flemington Apartments, a developer, been developing real estate for close to 15 years. We purchased this property with the previous approvals, as you know, and we're not involved in the process. We kind of inherited a project that was stalemate and needed some tweaking and working. We got to work and put together our best foot forward, trying to figure out the appropriate size, design, amenities, and so on and so forth, doing different market studies and analysis to really understand, the needs in this area in Florida. And we came before the board in the past, heard what the board had to say, went back to the drawing table, and again, kept on working the deal, trying to make it as close to what we heard and understood you wanted.
So you were part of the original approval process for the Spice Factory building, the phase 1 and phase 2, correct?
No.
So when we heard the board's concerns with respect to the architecture, that's something that, fair to say, you took the heart of coming back and instructing your experts to come up with a revised plan?
Yeah, it's actually deeper than that. The first time I heard that the board had input on the design, spent time on the design, was at the last hearing. Never was told that by the previous owners, but it was a design that they came up with. So that was new to me. A bit shocking, but we went back and tried to figure it out.
A question, well, during the time period that we had prior hearings, and circumstance has arisen with respect to the commercial space for the Regis, and what happened there?
Yeah, so literally the next morning, at 10 o'clock, I get an email from the rep at Regis. It's a national company. They have like 3,000 locations in the US, that they are vacating before September 20th. I was like, great, now what? I gave my attorney a call, literally a minute after.
And don't tell them what we said, because I have attorney-client privilege, but
we were taken aback, and that was sort of a curveball. And then again, just trying to figure out how to best situate ourselves with that developing. And we came up with this idea, all while taking into account the comments that were made at the hearing the night before. So we were able to minimize the mass of the building, and so on and so forth, step it back. Of course, the design, architecture, you'll hear. But still, it was sort of an opportunity at the same time. And we dealt with it as it came, but it was total surprise and shocker there.
Since that time, someone either on behalf of a limo company or Regis or had made a zoning permit application to allow the storage of limos in the parking lot. Did you have anything to do with that?
Nothing at all.
Did you grant approval for anybody to do that?
Not in any way, shape, or form. I actually reached out to my attorney who was handling the tenant, and they received a confirmation from Regis's attorney stating that don't get nervous, we're still leaving before September 30th, I'm sorry. But however, we do lease out for short-term tenants, sometimes even for a week, a day, but rest assured that, when the 30th comes, the place will be vacant. We will no longer stay there. Okay, no new leases will be coming in. And that was that. So we got that confirmation from their attorney in email. And I've shared that.
As the owner of the property, you have no intention of allowing anybody to have a limo company storing limousines on the front.
No, that's really the last thing we want to do.
The building two, where we had previously received phase one and phase two approval, where we're now planning on converting the first floor into the amenity space and some additional residential apartments. The upper floors, they're gonna remain the same as previously.
Correct, we're not touching anything there.
So the only change is gonna be with respect to the first floor.
Correct.
And Mr. Nusser and Mr. Zimbler will testify as to the specifics of that change.
Yeah, if I may just add, I think the beauty of it, we were able to maintain that it has the front portion still looking commercial like. We're keeping the amenities facing the pocket park. That will be there, so that worked out well. So really the front of the building remains the same. And then, you know, the additional units we were able to take off the fifth floor and put in there. Worked out well. So combination of the amenity space and the additional units is what resulted in the new plan.
Ms. McManus's report had some photographs that she updated her report, but there were some photographs from, I guess, the winter time showing a couch and some gaps in the fence. Am I allowed to share a screen?
You should be able to, now, you know,
Is disabled.
I'll fix that. Right to your own flash drive, that's a.
Now it's no longer available.
Go back over. Right, and that's what the problem is. So go over, so click on up top where it says click access, double click on VSD spot, not over there, but up top, towards the top of that window. The icon over, go to the right. This one? No. Not there. Right,
No, but I think I'm not in the USB drive. There must be an older one. This is.
yeah.
This should be it.
Shortcut from when you were there before.
Right.
And you can just, yeah, you could use some of those. We might need a new laptop, and I will bring that up to the mayor for the next budget.
Does this picture the picture that represents the area where the couch was in Ms. McManus's report?
Yes,
And it's not there anymore, and the site area has been cleaned up, correct?
correct.
Now
We're
we're,
up on a bi-weekly basis.
there's a staging area now for the work that's being taken place on building two, correct?
Correct.
So there is lumber and a dumpster out in that parking lot area, but is it fair to say you've been trying to maintain the garbage that was being collected by people going in the back there?
Yes, like we've indicated in the past hearing, we have 13 cameras on site that we are constantly monitoring on a daily basis, aside from the site manager on site. So we've actually fixed the fence twice in the last 3 months. I guess it's a convenient shortcut to the ball field. So we're on top of it, trying to maintain the garbage, beer cans. I personally believe the sooner we develop this, a lot of this will go away. People are around and the property is at its fullest use, you'll have a lot less dumping.
Let me show you, I'm gonna ask that. It's showing another area similar to the one that was in Ms. McManus's report where the fence is actually repaired. That wasn't repaired in the report, correct?
Yep. That's the lumber you were referring to.
And the lumber is in the lower right-hand corner.
Okay, so that's, I'm sorry, Mr. Grunberg, that was a picture that you guys took, so we need to mark that because that was not part of PB2, that's old report.
Yeah, we'll have to mark all 3 photos.
Okay.
So these are 3 photos taken by the applicant. Can you give a date approximately as to when they were taken?
August 21st, 2023.
Thank you. First photo shows a section of the fence and grass near or adjacent to the ball fields. This picture shows a section of fence repaired, I'm going to say adjacent to the Zimmerman property, right? Is that right?
It's actually not.
No.
No, this is the other side?
Yeah, it's on the other side.
Okay.
And the third is
Same side as the ball field.
By the ball fields. Is that adequate, Kara, for you to mark them?
Okay, they'll be marked as A10, A11, and A12.
That's all I have. Do any of the professionals have questions of the witness on testimony given? Seeing no. Kara, do you have anything?
I do not.
Any members of the board have any questions? No, we're good. Thank you. Sorry, any members of the public with questions for the witness? Seeing none, thank you.
Thank you.
Thank you.
Mr. Ziegler. We'll share my mistake. Mr. Ziegler was previously qualified as a licensed architect in the state of New Jersey.
Yeah, he's still qualified as an expert, but that continues.
Thank you. So, why don't you tell the board what you did in terms of revising the architecturals to meet what they were interested in after hearing their concern. You want to please get up and again. I'm going to these are the architectural plans that were submitted as part of our resubmission, so I don't believe that they need to be marked in valid.
Kara, correct? Those are plans dated 8/3/23. We don't need to mark them, right?
We do not. At some point, Mr. Grunberg and I will go through and discuss, what exhibits were replaced with others. For now, this will be considered part of A1, which was previously the application and plans.
Firstly, I want to start out by addressing, our testimony will be addressing some of the comments previously raised. The first one with respect to the plan, fifth floor, what we did in response to one of the concerns was we created an outdoor courtyard area facing Church Street. And by and large, what we did was we pulled the entire fifth floor back to accommodate the courtyard here and removing a substantial part of the fifth floor in the plan. So that was the primary change to the plan that we made. As far as the exterior. Some of the concerns that were raised, first of all, were for us to try to emulate the original Spice Factory building. We did spend some time looking for research and information on that building. Unfortunately, all we got was the revised building. We couldn't really find anything original. Just to speak to that, from what my understanding of the building itself was, I believe it was designed in the utilitarian industrial style that was late 18th, 19th, 20th century. And that style essentially is devoid of any decoration, any style, anything of any interest. It was really, we got in a utilitarian building, a brick box, and a warehouse. And we didn't feel that for this use and for the size of this building, that would be appropriate in any event. Creating a building which was just a simple brick box, I think would be unappealing to potential tenants, as well as the scale of the building would be potentially unappealing for the town as well. So what we did was we tried to create a new design reminiscent of a different style of that same period, which is the Federalist style. And again, I'm taking some liberties because I'm not a historical expert on the subject. But some of the elements of that are an ornate cornice with what are called modillions. And we'll look at that when we get into the rendering. And we try to use that ornate cornice throughout the design of the building on the top of the fourth floor. The other elements that we use to try to be reminiscent of an old warehouse building and a repurposed warehouse building for a apartment complex with a larger window areas and the vertical highlight of the window areas, as well as a larger constitution of brick on the exterior. If you recall, originally we had more panels, and now we're bringing in more brick, which again would be reminiscent of an older factory building design. We've also added, you can really see it here, but we've added a number of these vertical piers, which is also reminiscent of old warehouse buildings because of the rhythm of the buildings were vertical, and they had these vertical piers, which were really in response to the structure, the interior structure, and the column bays and so forth. The other items we created was a horizontal frieze or band along the top of the first floor, which would be a stone element. Some of the other features were, as you can see, we've added this rooftop courtyard facing Church Street. You can see it, you can really see it here on this, but again, when I look at the rendering, I think it'll be a little clearer. We looked at some railing to see if there were any railing design. I know that was brought up. We really couldn't find any old factory or warehouse buildings that had railings. So really, we wanted to just keep it simple. We didn't want to make it decorative or ornate. We wanted to just keep them as simple railings, which we're using as the Juliet balconies. Let me see. As I said, again, you can see here that we've reduced the fifth floor substantially. It's brought cut back here, and it's cut back on this side. We did want to try to make the entrance facing Church Street a little more interesting, and that's also kind of evocative of the original curved design that was on the previously approved building. So we did bring that element in, but in response to one of the concerns about the second floor being exposed glass and the possibility that people would have their window shades and it would detract from that appearance, what we did was we kept it curved. You can see here, but we made that part of the brick facade, so it wouldn't be a clear glass or reflective glass exterior for the apartment that was there. So, let me go to the rendering, I believe is, has to be entered.
Yeah, that rendering will have to be entered.
Okay, so we will mark that A13, and that is the architectural rendering. Can you give me the date of that?
Today. There's no date on the actual document. Yeah.
Oh, wait.
Okay.
No.
It's a photo file, just use that, yeah.
So as you can see, what we did was we utilized these cornice features along the top of the fourth floor. We utilized a stone frieze along between the first and second floors. We kept the glass, curved glass around the entrance lobby, but we converted the upper floor to brick. And again, we tried to create a more interesting entry. You can see it here. Oops. We tried to highlight the entry to first facing Church Street with a prominent entrance, just to make the entrance to the building more important than the balance of the building. You can see we're using a lot more brick. We're using vertical elements for the windows. We've also added more awning features, which is also somewhat reminiscent of the Spice Factory building. There's, you can see the rooftop courtyard here as well. And you can see we pulled back the fifth floor. And the design of the fifth floor is also reminiscent of old factory buildings, which would utilize sort of like a penthouse would have a metal siding. We don't want to use that, but we want to use a design that's reminiscent of that style in warehouses.
The balcony railings, what do they consist of?
They would be either wrought iron or aluminum, something very simple. Again, we want to try to maintain this as a simple building, more or less, which is try to make it seem as though a repurposed factory building. And I think the piers, and you can see these vertical elements here are reminiscent of it. The large glass areas and vertical elements here are also evocative of that style.
Open to questions from Mr. Zimmerman.
Questions from our professionals?
I had a question in regard to the bedroom distribution of, oh, sorry, thank you.
Get off your question.
Question that regarding the bedroom distribution for the affordable units, to ensure that it's consistent with COA, and then also that it will be consistent with the engineers.
Right.
But I just wanted confirmation that you're willing to meet the bedroom distribution for proper affordable housing and obviously for consistency between plans.
Yes, absolutely. I think last time we were here, we commented on the fact that the power units would be the same design as size of the regular market share units, the market units. So it's going to be an administrative something for the ownership, but it will comply.
And then I have to, and forgive me if I ask this question off the hearing, but something I'm asking, I'm making a note to ask all developers of affordable units. Is there a window in every bedroom?
Yes.
And every living or dining space?
Yes.
For the affordable units? Yes. How are the affordable units sized compared to the market rates of that same bedroom?
Again, we're not making a distinction.
Just want to make sure. Thank you very much.
I asked that last meeting.
Okay, thank you. I just want to make sure I check those boxes.
Yep.
Okay,
Bob, please.
unless I missed, I didn't hear you testifying anything about the modifications of the ground floor on building 2.
We'll talk to that then. So you wanted to questions on building 3 pieces? You didn't go to building 2, or I'm happy?
I mean,
I thought that was testimony.
It would be, why don't you just do all the testimony now, and then we can,
Sure, let's go.
because a lot of these questions, some
Sure,
of these
yeah.
questions kind of are how they all fit together, so.
Absolutely. So this essentially what we've done is created, I think, what is it, 7 additional, 1-bedroom apartments on the first floor. Where the Regis space was previously. And then those units essentially surrounded the back and the side. The only real modifications we would need to make is some window changes to accommodate apartment units versus where they were, but again, those would be on the rear. And I'm not sure, probably maybe a couple on the side, but we essentially kept, I think we had 2 units. We had 2 units here as well. And then we had amenity spaces in front here for the use of the
That amenity spaces for both the buildings, correct?
yes.
And I'm just making sure, just clarification to read this, that's the community room and the gym
Yes.
and a public restroom. And what else is in? Is that in a bike storage? Is that what I understand?
I don't recall the. Yes, I'm sorry.
So those, the amenities that we're talking about now putting into the first floor of building are the gym, the community room, and bike, secure bike storage. Okay.
Must need to testify with respect to the first floor of building 2.
No, again, it was mostly just an interior change and the exterior, other than locating windows where we needed to have them for light and ventilation of the apartments. Exterior was stayed the same.
So Bob, why don't you ask your question now that he's getting?
Yeah, so the bathrooms, they're not, are they showers or are they just strictly
No,
bathrooms?
those are the bathrooms.
And they're connected strictly to the gym and to the community room?
Yes, they will be.
Okay. And your lobby entrance on the side of the building, when you go to the site plan, I think I raised this the last time, that is essentially putting the main pedestrian access into the building right next to the dumpsters. Is that the intent? Because the site plan would sort of indicate that the main access to the building is where you're showing the package room.
Yes, I don't recall why we modified that, but I think we needed to have a package room, and that was really the only space that would have worked. So
Just again, when we get to the site plan issue, that's the main access. The main access to people into this building is from the side next to the dumpster.
I'm not sure that's changed from the original design. The original building 2 approval. I don't recall that. I wasn't involved in the original building 2 approval, but I believe that's what the main entrance was.
I'm not sure it was, but that's.
Whether or not.
Right, but the testimony is that as the plans are right now, the entrance to the first floor of building 2, existing structure is on the north side, which is also adjacent, which is the space between buildings 1 and building 2, and that's where the dumpsters are. Yeah, I believe that's what the testimony is. Okay.
One more item now that we have the new building, the new architecture for the building. I just want to confirm that the certain building materials and elements of the proposed building are going to be as similar as possible to what we see on the existing Spice Factory. And I'm thinking in particular, because I think it's your intention, I'm thinking about the awnings and the brick color. I understand you may not be able to literally match the brick given the age of the Spice Factory, but I think the board would like assurance in a condition of any approval that might be granted that states that those materials will be substantially similar in appearance to those on the Spice Factory
To
building.
the extent we can.
Okay, I would ask those materials just be submitted in advance, just advanced construction, that is, just to confirm the appropriateness.
Right, and that's something that we can make a condition of approvals if granted that we can handle with the sports professionals. Kara, did you have any questions for the architect?
You know,
Yeah, you're good. Good. Members of the board, questions for the architect?
Yeah, I have questions. Keeping this architectural plan up, I can't remember, are there, where you said little community rooms and pool table, are there also doors to the parking lot there? Are they all windows? No. Are there any doors? No. So the only way into either the community room or the gym is through the lobby area that Mr. Clerico was referencing back, or you can go in through the front.
There's a side door.
Okay, and right where you're looking, that door, that stair, where does that stairway lead to? I know it's existing. I just don't understand why it's not connected to the hall.
It goes to the upper floors. It's egress stairs to the upper.
So, but you, if you were in the gym, your only way up, you would be to go outside the building and go up, or go to the back of the building and go up the elevators.
Yeah, we can still refine this plan to the extent where, it would continue to be more practical, but yeah, we could certainly have an interest in stairway.
Yeah, I mean, it's not a land use issue per se. It's just that when you look at it in plan, you begs the reader to say, geez, wouldn't it be nice if you just run upstairs from the gym?
Well, we do have the elevator access.
Right, I see. And then going back to the either the rendering or the isometrics rendering or the other. Okay, on that, I understand and see the courtyard and the railing. Are you also outfitting the back of the building with that same intention? Because I also see the same railing up back. But not necessarily, it just says roof. It doesn't necessarily on the back, on the rear of the building.
Yeah, I mean, we would need to have a railing just for full protection, but we weren't intending to make that area courtyard as well.
Okay. That's a great view of baseball. So and the materials in between you did a great job on the vertical fenestrations, whatever you call them on an architect. What is the material in between the windows? I see it's brick in between the Juliet style, but what is it? Appears white and stone. All right.
Yeah, I mean, the intention is we make a fiber cement panel or something decorative. We don't know exactly what we want. We're really just trying to establish the vertical look of it and to continue the look of the window line. We didn't want it to be brick because we were trying to emphasize the vertical.
Okay, so what we're seeing now is just a representation of some light colored block, or could it be a dark colored block as well?
It could be, yes. Again, the intention was to create a continuous vertical element reminiscent of the factory.
Yeah, because since the windows essentially read black, it could be a dark and really emphasize a vertical nature. I mean,
I mean, when we look at it, we kind of get tunnel vision, and then, when someone else kind of brings things to our attention, we say, yeah, well, that makes sense too.
And on the entrance facing Church Street, which you can just see in the corner, is that large? Is that a round window? Is that a clock? What is it? It's a round
window. It's a decorative element because there's an apartment behind it.
Oh, so that's like a decorative stone element,
yes.
If you will, or some kind of block element.
Yes.
Okay, those are all my questions. Thank you.
Dennis, please.
Hi, keep it on this page. See in the back where the white car is, there's a single window right on the edge on each floor. And what struck me first was the wall, like not much window, but then I saw there's a window there. Can you go to the floor plan? Because on the floor plan, it looks like there's no window on that side in the bedroom. Like if you go to page, I think it was page 2 or 3, it looks like, yeah, 1D is the one right there. See at the top where the bed is, it doesn't look like there's window right there where the bed is in 1D.
We worked on the element, we created a rhythm, we created a look, so the plan, I apologize, will when we fine tune this, will represent the exterior in plan as well.
Okay, thank you.
Right, can you say that again, that the plan will represent the
We-
rendering or the
Yeah, we do
rendering?
plans
represent-
and then we develop the exterior, and the exterior look is something that we want to come across. And if we think that that wall was too much brick or too massive, then we, in the exterior representation of that, we'll put a window in. But, we'll have to go back to the plan and coordinate that. So that it works, because the exterior is what we're looking for. To try to work.
I would think there needs, it just needs.
Yeah.
Hannah, please.
Hi, if you could just go back to the other rendering, the 3D rendering. I just had a quick question about the entrance. The glass windows. Is it just stairs there, or is there any kind of wheelchair access?
The door, you see the door here?
The gray door?
The door is a handicap entry to the lobby area.
Okay. But that's the only way they have to get in there. Is there going to be any form of like automatic door opening there?
When we get into the details of it.
Okay.
Make
Okay.
that-
And that leads right to that would lead to right to the lobby? Sorry.
He answered yes.
Okay, sorry, thank you. Thank you. That was my question.
A little window dressing unintended on that door, if that's as an entrance for residents. I had not picked up that was gonna need to be the ADA
Sure, yeah.
entrance, but I bet.
We could also put an awning over it.
That's what I'm thinking, the
Yeah,
awning, and it looks like a utility door, which if it's a utility door, that might be fine, but given that I think it's
Yeah.
gonna be more booze.
Mhm.
There's no particular plan submitted here for the roof of the structure itself. Where would the mechanical equipment be?
It would be towards the middle of the roof structure, so it would not be.
On top of the fifth floor? Would it be,
Yes.
would the exposed part of the top of the fourth floor at the back of this building?
I don't believe we have a need to do that. I think we can get all the equipment required into the middle of the top floor. So I think there'd be a need to put anything on the top of the fourth floor.
And the elevator shafts would be penetrations up to that area as well?
Right.
Because there's gonna be a question and yes of the engineer regarding calculation on building height and the limitations with the ordinance to document that we're actually in compliance with various elements.
Need to provide any testimony with respect to building height.
It's basically what we had provided originally.
Okay, any other questions from members of the board?
I just have a follow-up question on the architectural plans. It says brick veneer. It's brick, right? I mean, is there a difference between brick veneer and brick?
Well, it's called brick veneer because it's building.
Okay, but it's not, it's brick. It's a brick building, not a pardon my term, Garden State brick basins. No. I'm just checking. The word veneer sometimes scares me.
It's not.
Typically we call brick veneer.
That's what I thought.
Okay. Any other questions from members of the board? Any questions from members of the public? Thank you.
Mr. Nasser. Qualified as an engineer and planner, and it's fun to go over the changes to the plans since the last time.
Yeah, we could, might have to stop sharing. Sorry. Every trade show, every conference, they give away, I have a fistful of these things. Everybody's firm on them, so.
It's because we really prelude on it.
And then it's all yours. It's all ours stuff.
Got a national conference, you get all sorts.
So is this a new exhibit or?
It is a new exhibit.
Why don't you identify that first?
So it's titled Site Plan Exhibit. And it's dated with today's date, August 22nd, 2023. It is the site plan with the landscaping overlaid on top of it, an aerial photograph beneath it, and then color rendered for the areas of the improvements.
I think that being marked as exhibit A14.
Correct. Yep, 814.
If you wouldn't mind.
You-
There's a lot of detail on here that might be easier to see. I'm sorry, sorry, Marcy. Control L, but.
I'm gonna hit F11 because I was thinking that's what full screen. Sideways. Okay, so just again, going through the changes that have occurred to the plan. For the most part, it's just a promulgation of all the changes that we've gone through via exhibit. As we've gone through the process, we've included the sidewalks into the plan set now that we've talked about, connecting the western parking lot, which is page up with this section here, connecting it across the basin into the sidewalk network, as well as the new sidewalk along the west side of the northern parking lot, and bringing that again, connecting it into the site network. Obviously, the building footprint has been updated from the new architecturals. The revised entrances have been added to the plan. The existing entrances on the face of building 2 have been removed where they're not entrances anymore. The EV spaces are now, again, the correct number in the locations that we've discussed, located behind the building and then along the northern property edge. Again, we've adjusted the stormwater basin for the fact that we've moved the wall in 4 feet to accommodate the sidewalk. We maintain the stage storage, if you will, within the basin so that it maintains that it holds the same volume at the same levels as it did previously. So the basin is proposed to operate identically to how it was previously approved as part of the last application. The green roof, which was previously proposed as part of the building, because of how the 5th floor has been shrunk down and the location of the utilities, that has been removed. So the impervious coverage calculations no longer account for that 5,000 square foot of green roof space, which from a administrative standpoint has led to an increase in impervious coverage, though it's still below the 70% allowable within the zone.
So we don't need variance relief for impervious.
No, there's no relief for impervious coverage.
Part of the benefit of doing that though is because now we're gonna add that courtyard area onto the one area that used to be roof, correct?
Kara, actually, sorry.
I'm in her seat.
You're in her seat, sorry.
I appreciate that you guys are below, the application is below the 70% in the zoning ordinance, but this borough also has that ordinance that reduces the permitted impervious cover by 20 percentage points unless they meet certain stormwater management standards. I don't believe that.
We discussed this at length in the previous hearings.
Yeah.
The existing basin located here, as was requested as for the same reason in the prior application, is being reconstructed from being a detention basin to being a bioinfiltration basin.
And the extension of the parking lot is being designed with porous pavement. The green roof actually does not, for the ordinance, count towards the it's always so awkward because it doesn't help you avoid the penalty of 20%. So it's our opinion that the improvements to the existing stormwater infrastructure, as well as the porous asphalt in the proposed, takes us across the threshold of providing those items and not making us suffer the penalty.
What was the reason for eliminating the green?
As I said, because we've reduced the size of the 5th floor down, it's now smaller, and with placing the utilities within that roof space, it reduces the opportunity to see the green roof in there.
And also the courtyard area as well, that had an architectural feature that had been indicated would be nice along Church Road.
Yes.
Well, my question goes to the rear of the building, where we only have the 4th floor exposed. The question I asked was whether they're going to use that for mechanical equipment. The answer was no.
Correct.
So you do have a nice flat roof there in an area that I don't know if it's equivalent in size to what you were previously proposing as part of the close-up equivalency. It's a question is why are you not doing a green roof on that?
You know, honestly, we didn't consider putting a green roof on that 4th floor within that space. If it's as simple as that, you know, I think
At this point, though, we don't require it because we're meeting the stormwater reg, so we don't need to reduce the, we don't get the 20% penalty. Is that your testimony?
right. I mean, ultimately, the benefit of the green roof is simply for meeting the impervious coverage. It allows you to reduce your overall impervious coverage on the property. It's not, it's nothing to do with the 20% penalty, avoiding the 20% penalty.
I guess the point is that in all of our, not only does the reconfiguration and reduction in the size of the 5th floor limit the space, lots of money and time and efforts being made to come up with this revised plan, which has driven up the cost, and I can present Mr. Yanay's testimony with respect to this. So we're doing our best to address the concerns of the board, but at some point, if a features is no longer necessary or required for the benefit of reducing the size of the building, massing of the building, providing the courtyard, I think there's an economical reason for not doing the green roof as well.
No, I don't recall hearing as part of the 20%. There's also 3 additional residential units being proposed as part of this amended project.
That's correct.
Yeah, so where previously 113 were proposed, we now have 116, and with a reduction of the office space on the 1st floor.
We're eliminating the commercial space on the 1st floor in favor of 3 additional units overall, correct?
Correct.
And that's because we're losing the units that were on the 5th floor originally proposed. The number of those units.
Right, so units were removed on the 5th floor. Again, in the reconfiguration of space, units were added to the 1st floor of building 2. So, you know, overall, the building 3 has reduced in scope on that, especially on that 5th floor, with the units again going into the 1st floor of building 2. 2 other very quick things. Number 1, we added a speed bump at the eastern end of the property as it goes into 78 Church Street by the American Tire. We still have the speed bump on the western parking lot, as well as the speed table, which integrates a speed bump along with the crosswalk by the basin.
And that was to address the concerns raised by certain board members of people trying to bypass to Broad Street, correct?
Yes. And then additionally, because we have the secure bike storage room within the building, we meet the ordinance requirements for, exceed the ordinance requirements for providing bike storage by having it internal. So it's covered, it's dry, it's secure. And so the external bike racks have been removed from the plan. And then finally, the landscaping was revised to increase the number of trees around the parking lot to get us into compliance with the parking lot tree requirement, the number of trees.
So I know Ms. Stewart isn't here this evening, but I think that would make her happy because that was the comment that members of the public had with respect to those trees. Anything else from an engineering standpoint that you'd like to point out from a difference from the prior plans of what we have now? We can either stop there or I can ask them some planning questions.
Let's actually stop there because it's giving engineering testimony and the planning testimony. I know you're getting equipment last year, but that's not, it would just be easier that way. So, engineering questions, Bob, I know you asked a few. Do you have others?
Yes. This is a bit of a confusing application because it's a continuation of things we had before that we had in the form of exhibits and now we have in the form of a plan. Just refresh maybe as part of the testimony, what you're doing in the way of replacement of fencing along the, I guess that would be the northwest side of the property.
Sure. So that would be to lot 3.01, which is this triangular lot. So there is an existing wood stockade fence on a portion of this property line, kind of extending from the current property line coming around. All that's being replaced and extended to this rear property line to the railroad. And then again, to the front edge of the parking spaces with a 6-foot high stockade fence. It would be a vinyl fence as opposed to the wood fence that's there now. And the section, as we discussed previously, that was within the front yard setback because the front yard setback fence can only be 4 feet high. Within that space, it would be 4 feet high, transitioning to 6 feet behind the front yard setback.
And the existing fence, there was some discussion on earlier that's in various stages of, well, I'm gonna say just repair. The applicant's making lots of efforts to keep repairing a fence that keeps getting damaged. The northern, the leg of that fence that's right behind the north face of the building number 3, that fence is being relocated as part of this project?
Yeah, that fence would be relocated as part of the project because right now it's right back to the parking spaces. It was a result of, there was a change years back in the property line where the property line actually was where that fence is. And now that narrow strip is again part of this lot. So the fence would be relocated.
That fence in your relocated plan, I didn't pick up on this till tonight, that your plan needs to reflect the fact that fence is being relocated. It doesn't say that right.
I mean,
and if it's being relocated, will it be the vinyl fence you're putting back up and you're gonna be putting out in front of you?
Absolutely, the vinyl fence, new vinyl fence.
And the fence is there, is on your property, up the fence that's along the northerly, I guess it would be the northerly stem of the east side of the northerly stem of the property.
This, if you're looking.
Yes, here, that area there. That fence is on your property and it's a stockade fence, but the stockade section is facing the property, not facing the neighboring property, which in this case is ball fields.
Correct.
And it wasn't installed by the borough, it was installed, this fence is it?
I don't know. I don't know who installed the fence. I mean, yes, it is.
It's typically a screening fence is installed with the good side facing the neighbor.
Correct. Yes, so I don't know if it was installed by the borough on this property or if it was installed by a prior owner. on this location, and they just were being vain about the location of it. But ultimately, the fence is cleanly on the subject property.
The entrance to building number 2, on the architect's plan, it shows the main entrance to the building next to the dumpsters. Your site plan would sort of indicate you're putting a very nice brick wide walkway up to what, according to the architectural plan, is going to be I forget what it was.
It's a package store.
Package.
So it's because it's the existing walkway that's there, and the issue with the walkway going not just up to the door, but along the building, in its current state, because this is again one of the improvements of phase 1. In its current state, the cross slope of it is somewhere around 8%. So it's not compliant from an accessible standpoint. It's not compliant, generally.
No, I understand.
So
That wasn't my question.
it's not that so the point would be we're not installing that. It's reconstructing what's currently there to make it comply.
Okay. But just factually for the record, the main lobby entrance, the main entrance into this building from the parking lot are the doors next to the dumpster.
Yes.
Okay.
It's the doors next to the dumpster.
Okay. Building height. Can you go into how the building? There's a question about you're asking for variance relief on building height, relating to building number 3, and there's some question about what the mean elevation around the building is, what the actual height of the building is. It was a question I asked of the architect. There's some limitations on the what you can have on the roof and percentage of coverage. The representation is that they're complying with that, whatever that is, they're complying with it. There's no representation on the plan of exactly how they're doing that, but there's a. So the question is, can you offer some testimony as what the actual height of building number 3 is?
Sure. Just a quick step back. When you say the coverage of the building, you're talking about coverage of mechanical equipment on the.
Well, the ordinance, I kind of summarized in my report, but the ordinance allows for penthouses and things associated with parapets on the roof, but they can't exceed more like whatever I said, 5% of the roof area. We don't have a plan of the 5th floor roof area. The representation that they're not going to exceed that 5% factor. But the other factor was the elevation is, so we're measuring to the roof of the 5th floor is the top threshold for determining building height for elevation. But it's the mean elevation around the building, and I noticed that you actually have some grade differential around the building.
Yeah, there is some grade differential around the building, and honestly, after all these years of going back and forth on this application, I'm surprised at myself that I didn't see this earlier, and certainly wasn't a comment that I was aware of earlier about that. So it's been, and I apologize to the board for this, little beyond my sight, if you will, on this being something in order to come up when it did was, let's call it inconvenient. I will say that we are going to make some efforts to regrade around the building to raise the grade around it, specifically on the east side of the building. We are basically at finished floor grade from the front entrance around the west side of the building to about this rear door, maybe mid in the tail section of the building. After that, the grade's actually slightly above the finished floor of the building as it comes around the back. And then again, we're losing some grade along the east side. So we're going to make some adjustments in there so that the average grade around the building matches the finished floor.
Well, it's not the average grade, it's the mean grade is what the ordinance says, which I always thought to mean the high and low elevations. On the south end of this building, you have about 4 or 5 foot. The grade is about 4 or 5 feet lower than the first floor. You actually have steps coming up
There's
to the
a,
main entrance.
well, there's a wall against the building and then steps up. The lowest grade is that south
The
east.
south end, because you're up against the driveway.
Right, we're up against the driveway. So, yeah, I guess a solid understanding of the mean and how the mean is calculated. I understand the mean to be the average and not just the average of the high and the low.
Mean and average, okay, stats professor, sorry, mean and average are the same.
Okay.
Mathematical mean is the mathematical average. It's you sum up the elements within a series and divide by the n number of cases, if you want to be precise.
We're
the hives.
Okay, that's sorry. But if you want to, I'm not going to talk about what ordinances say, and I don't want to weigh in on what engineering principles are. If you want to calculate if we have an ordinance that says the mean height of a building is calculated by taking the high by the low and dividing by 2, that if you what the ordinance says, I'm just saying that the words mean and average are synonyms.
Yeah, I just want to get factually. So want to get facts. At some point, the applicant's going to ask you to vote on variance. I think you have to know factually what's the extent of that variance. And right now, it's well, there's some elements on the plan that says it's 60 some odd feet. It's an architectural plan. If you just look at the floor elevations, it would say it's 50 feet. But then it doesn't go into what the definition, how we calculate the mean average. So it's something more than 50 feet.
Right.
We just don't have, at least I don't know what that number is.
The roof elevation, the 5th floor roof elevation is 50 feet above the finished floor.
That's what the architectural plan says.
Correct. And then the parapet is a further 8 feet above that at 58.
I think we exclude the parapet.
I believe you do.
I think we do also, but we're going to check that. But that's, so it's 50 feet above finished floor.
Right.
The testimony you just gave is that there are parts of the building that are above or below finished floor, right? Above grade from finished floors above or below grade.
Below grade, no,
It's
nothing.
below grade.
There's parts where the finished floor, the rear of the building, the finished floor is below the grade, and in front it's at grade.
My understanding is it was previously approved as 58.
It was.
And that's what we're showing.
58 inclusive of the parapet or 58 as the roof line?
I think it's the roof.
No, it is just what's presented.
Okay.
Yeah.
So the testimony, okay, just for the record, testimony is that prior approvals had 58 feet allowed. The application in front of us is that the building itself from finished floor to roof is 50 feet. The parapet is an additional 8 feet, and whether or not we count the parapet, Beth is feverishly looking at the ordinance to confirm the relief sought will either be one or the other, in terms of what Bob is asking for. But the testimony is that it's 50 feet and an 8-foot parapet.
Correct.
That
Right, and I think the concern is on Bob's and rightfully so, to make sure that we don't get relief that doesn't actually adequately cover it. If there is equipment on there and it exceeds 5% of the roof area, that would be adding to the roof height. Correct? That's
Well, no, you're only allowed, well, I'm not sure. I go back to Beth on that. You're what you put on the roof for mechanical equipment, for penthouses, for elevators is exempt as long as it doesn't exceed 5%.
That's correct. I've got the ordinance in front of me if anybody wants me to read through it, but essentially that's it. There are penthouses and roof structures. There are other components that are allowed, provided they don't cover more than 5%. If they do, then they get calculated into the overall height calculation.
5% of what?
The roof area.
the roof area, which is
The 5th floor roof.
The
area.
fifth floor.
fifth floor roof area.
Yeah.
Okay. Because the total building roof area is 68,000 square feet, and you have
So while the architect is doing some math, we could move on to other aspects of testimony. I want to keep things moving if we could. Is it break time? Oh, it is 9 o'clock. It is, okay, so let's do this. Figure out the math, we'll figure out this. We'll pause here and take our break. Let's keep it to like, well, it's hot, everyone should get some air. So let's keep it to no more than 10, please. Okay, we're going to come back to session. If we could, I'm gonna ask Eileen, please, could you recall the roll?
Well, we do have, Mayor Carroll and Councilwoman Engelhardt were recused and left the meeting at 7:35. Mr. Campion.
Here.
Mr. Dashna.
Here.
Mr. Levitt.
Here.
Mr. Cook.
Here, I was gonna say hi. Here.
Ms. Weitzman.
Here.
Mr. Hill.
Jim, are you there? Say
I
hi.
see.
I see him. He's waving. Good, he's here.
Thank you. Mr. Semino.
Here.
Mr. Eckel.
Here.
Mr. Show.
Here.
Kaczynski.
Here.
Mr. Clerico.
Here.
Ms. McManus. Here. Mr. Chapman.
Here.
Okay, so we were figuring out heights of buildings. That was
So, yes, so ultimately, reviewing the ordinance, parapet does count, it's not accepted. So 58 feet is the height, and I'm going to share screen again. Full screen. There. They're still on. Is going to be. So again, the roof height for the 5th floor was at 50, the highest parapet. So it's just the highest parapet here, which is not the entirety of it. I just want to make sure it was clear to the board that that there's these 2 areas here that are at 58, but the remaining areas are lower than that. And so that's the relief that we would be seeking is 58. So the discussion about the equipment, all the equipment's below that elevation to begin with. So it's not kind of makes it.
So the highest element of the building is 58 feet. Any equipment or elevator penetrations or any of the rest of that will be at or below that height. That's the testimony that you're giving.
That was correct.
Okay, so the relief sought, just to get a picture, is that they're proposing a structure of 58 feet.
Correct.
That was what was previously approved as well, correct?
Correct.
And your mean grade around the building, you're saying is the building floor elevation?
It will be. Yes, we will have to make some adjustments, but it will be. It will be. We'll have to regrade on the east side of the building.
Whatever relief the board grants relief, they're going to grant relief for what you're requesting.
I'm very aware.
Should it turn out later that you didn't ask for the right stuff, you're going to be back here.
I'm very.
Which is why we're making sure we got.
That's why we're making it.
I'm very aware.
Okay, so we're good. Bob, did you have other questions?
Not that I can think of.
That's fine. Any other questions on the engineering testimony from the board's professionals? Yeah, Jay.
I just have one. My only
Could you
question.
do me a favor and slide the microphone over just to determine we can.
My only question is, can you add traffic control signage and striping to that access driveway to Broad Street? I haven't seen that show up in any of the plans.
Oh, yes, absolutely.
And maybe I don't recall the testimony here, but you go back over what you're parking, how you're compliant with parking. I know you mentioned 5 EV spaces, just for the record.
Yes.
Because the number of housing units changed, the retail size changed, so we have to.
Yeah. So, and I have a correction to make in that as well. There was a comment in Ms. McManus's memo, as well as Mr. Clerico's memo, about the size of building 1, the existing powerhouse building. The footprint of that building is 2,701 feet. There is a mezzanine that's slightly more than 1,000 square feet. It's 1,042 square feet. Within that space, we had assumed that mezzanine wasn't occupiable space that would generate either floor area or parking demand. Had a discussion with Ms. McManus today, and it's her opinion, which after we discussed it, I concur with her opinion that it in fact does. And that space would generate, it's currently being used as storage by the salon. And it would generate as retail space. So it would generate an additional four parking stalls. Okay. So clarifying that, and it also adds, again, 1,042 square feet to the floor area ratio of the site, which amounts to 0.006 to the FAR. So where the FAR is noted on the plan as 0.687, it would actually, it should actually be 0.693. So just to clarify that.
And does that trigger parking variance relief?
It now does, unfortunately, but yes.
And what was the parking spaces provided and parking spaces required?
So the parking spaces required for the site would now be 209 spaces required, with 206 provided. So we would be deficient by 3 spaces due to this additional mezzanine area. Certainly significant reduction over the relief that we had previously sought, which was, I believe, 25 spaces. It's certainly much less than the relief that was previously granted for this application. Again, I don't want to belabor the testimony that I gave last time, because I think it was lengthy, and Steve will probably pull me out of here if I start going back down into it. But suffice it to say that I believe that the site has more than sufficient parking available for the uses, despite this this slight deficiency. The space is being used again currently as storage. Not that it's necessarily restricted to that, but even unrestricted from or it not being storage and being normal retail space. Again, the way the site would operate, the amount of parking that based on our analysis is required for the site, we again have more than sufficient parking for what the needs are here.
Any other questions, Bob?
At some point, I guess we're before, but now.
Okay, so Beth, your question?
If I can, Mr. Chair, before we start that, just a couple cleanup items. We've got a few more planning board exhibits to enter. We'll enter as PB8. That will be the traffic engineer's report of August 21st, 2023. PB9 is the engineer's report, also dated August 21st, 2023. And PB10 will be the planner's report dated August 16th, 2023.
Thanks.
I have a handful of questions identified in my report that I can go through with them.
It's not on this one so far on the engineering stuff. We'll come back, we'll do the planning stuff in a second and we'll hold it there. So if there's other engineering questions, let's go to members of the board who have questions. No. My question was on the parking that Bob already just asked, so I think we've covered that. Again, I'm sorry, there was just one thing. I just want to make sure we've got this exactly right. Testimony given is that the improvements that you are going to do on the stormwater conversion of the detention basin, as well as the permeable pavement for parking that's on the lot 4 section. Your testimony is that those things satisfy the requirements that you do not need to go to a 50% impervious, that the 70% standard is applicable.
Correct.
And that you will comply with DMPs to make sure that you're able to do so.
Yes.
Okay. There was stormwater was raised in a couple of places. I just want to make sure I understood what your testimony was. Okay. Okay.
So you just personally.
Yeah.
So quick question, your calculation on trees, thank you for meeting our ordinance. Do they include, I see trees in the drawings on the roof. No, in other words, there's some.
On his rendering.
Yeah.
No,
So they do not include, your calculations do not include, it's all pure.
it's the plantings in the ground around it, yes.
Oh, you mean like on the patio?
Yeah, there's trees, they look like trees.
Good catch, I didn't pick that.
You can't. Yeah, I wanted to make sure.
Sorry, just trying to make sure I'm not playing fast. Playing fast.
So a fig tree on a patio doesn't count. Okay. Any of our remote participants have questions? Any of the members of the public? Okay. So you have testimony on planning.
Yes, Chris, I want to limit your testimony because I think we provided it all in the past, but there's only one real change, which is the change from the commercial space on the first floor of building two to residential space. And there's all the justification for allowing a residential use in this district that you testified to previously, or all those justifications apply to allowing it on building two first floor as well.
Yeah, expanding it down to the first floor as well, yes.
And how is that a benefit to the borough by allowing that type of change from the commercial use on the first floor to residential under our unique circumstances?
Well, I think in our circumstances, it allows us to reconfigure the site in a way that it's more conducive to what the borough is looking for here, reducing the scale and massing of the third building. I think the way it's being developed by keeping the storefront faces on there so that the site still looks as if it is a mixed use, which it is still a mixed use development. We still have the salon on the property, but maintaining that storefront look on the existing Spice Factory building, I think helps maintain the view as well.
Is it that type of use also consistent with the other uses in the neighborhood, particularly the other residential development on Church Street?
Yes. Again, this immediate adjacent property to the southwest of us is a purely residential facility.
And the change of our parking variance, which we did notice for any and all other variances that might be required. The same testimony in support of those parking variances applies to our 3 parking space variance as well in terms of the positive and negative criteria.
Yes, again, I really just stated, we're far more compliant than we were previously, and the testimony that I had given was that we had more than sufficient parking at that time, and certainly that wouldn't change.
I have no other questions from a planning standpoint.
So Beth, why don't we let you go through if you have any important questions?
Yeah, I do about that. I do have a couple items that are outstanding. I was asking for detail of the proposed EV charging station. I presume that could be provided as a condition of any approval.
Yes.
On the landscaping plan, I appreciate the additional trees that have been added, but I think what's being proposed is using some trees located around the parking areas in order to satisfy the parking lot tree requirements. And I want to ensure that there's no double counting, if you will, between trees that are required for the purpose of the parking lot versus trees that are required and proposed for the purpose of the buffers around the property. And so unless the board would like, I'm not necessarily asking for an accounting of the trees, for you to take a moment and count the trees to determine which requirement they might be satisfying. I recommend with the landscape plan, but I'd ask that should there be any deficiency identified as a condition of approval, that the applicant is required to make a payment in lieu of tree plantings, if that's found to be necessary.
And I got a nod in the back, yes.
Great. Thank you.
And just to clarify on the requirements for buffering for the site.
I think you guys are largely using the filtered buffer.
Is the filtered buffer? In my reading of the ordinance before, there didn't seem to be any, in certainly some of the areas that are noted in 7.1 on your memo. It said no fencing or evergreen screening is proposed along the proposed building or bioretention basin, but there would be no requirements for the ordinance that provided in those locations for that 1632 A A6C. Just going to, I mean, that it speaks to against the parking lot, and those features aren't the parking lot. So, I mean, I'm certainly will comply where necessary in there. I just don't.
We'll work that out.
When I look at it, I don't know that the trees that we're proposing would be screened, the fencing that was proposed.
And yes, I agree that one of the provisions of the filter buffer requirements in the borough's ordinance is it allows you to utilize the fence where inadequate buffer space permits. I simply haven't gone through the plan to confirm exactly where you have a fence versus where you have trees, whether the trees are performing a screening function or whether they're performing a parking lot function. I just want to make sure we're not double counting. I think that my opinion for the board is that they provided adequate buffering. I just want to make sure the trees are being allocated properly from a compliance perspective.
Yeah, more than fair.
And I mean, again, it's a technical matter, if it turns out that in that review, there is a tree or two deficient, we wouldn't want you to have to come back for variance relief, right? So that what Beth is asking is, in that case, if there were to be found that deficiency, since you're not asking for relief from that, the board would not be granting that payment in lieu to the tree fund is the way to satisfy the requirement.
And I would offer, I would be happy to work with the applicant on that as a condition of any approval, including working with you should you determine there are opportunities for additional plantings as opposed to a payment in lieu.
Right, yeah, I think we obviously look for opportunities first to plant more, and if there aren't, then we would move to make a payment. So we thank you for that.
And then I wanted to revisit the lighting that's proposed on the property. I know that we had addressed this at the last hearing, and I don't know that the board had weighed in on its thoughts. We typically look for LED light fixtures on a property. The site is utilizing HPS, high sodium, as well as, if I'm not mistaken, yes. But I think what the board needs to consider is that this is a different circumstance, not simply the applicant just simply installing new HPS or metal halide, but it's their request to continue to use the existing light fixtures on the property as opposed to replace them for LED fixtures. I think that this is an environmental issue for the board to weigh in on. Certainly, it's two competing goals. One is reduction of waste and not undoing properly working infrastructure versus the desire to move towards LED lighting. I think that's, like I said, I see it as competing environmental goals that the board should weigh in on.
I think we were also trying to use the existing historic style lighting fixtures. They were of an architectural style that the board had previously granted the relief from to continue to use the historic style fixtures. And that would be the reason primarily what we'd like to keep using in the manner that they were, making sure that everything's functioning and working, but not switching them out for newer features or newer.
So,
Well, we will.
so my question is actually really more for the board. I think that's something we need to weigh in on. I had asked for candle values to be extended on the lighting plan. I don't think we want to see a condition of any approval. Should the board determine to grant an approval, I'd be happy to stand on addressing any lighting plan concerns that may be necessary depending on the board's decision on the light fixtures themselves for additional reasons. And then I think my last question was, I had just wanted to revisit the testimony that had been provided on the proposed hours of operation for lighting. I couldn't recall if we've committed to reducing down for security levels in the evening, or how that might be addressed.
We did agree to reduce the lighting to security levels only during evening hours. I can't recall the specifics of that 3 meetings ago either, but I know the testimony was in there that we did commit to reducing the security levels.
Thank you. Those are all my questions.
Planning questions, Jay, or are you good? Bob?
No, no planning questions.
All right. Other members of the board? Bob?
Yeah, I guess this is a fun question for the lighting. Where are the new wall packs going? Specifically? Are those new or are those already exist?
The wall packs are proposed. They are. There are 4 proposed. One is located on the rear of the building. One is located here on the west side of the building. And then the other 2 are located above the grass area here on this portion of the west side of the building.
Here's my follow-up question. If it would be possible, if there's any other type of light fixture, I suppose that could perhaps better shielded one that could meet the needs of an area lighting that you're going for there. That's a little more shielded or direction, something of that nature. I don't necessarily need an answer, particular considerations.
Yeah, we certainly consider that. And I think that the concern in a couple of aspects is there's not a lot of space off the edge of the building in this area, more so. But on this portion of the side and the rear of the building, there's not a lot of space. So you'll end up with if we put in a post mounted fixture, we can post mounted fixture right next to some window. So it's more advantageous for tenants to have the buildings mounted lights. But we can certainly look to that. We can work with Ms. McManus on upgrading that or changing that out to maybe fit a little better.
Is there, thanks, Beth, for bringing that dueling environmental issues, because sometimes we forget and say, oh, I want all LED, but then all those lights go to a landfill and it's opposite. But is there a way to sort of have your cake and eat it too? Like, I mean, like a condition, and I'm asking that as repairs are needed, they get upgraded on a systemic basis of some way. I'm not even sure that's possible.
I've never dealt with conditions, quite honestly. I don't know how that's enforced.
Just that I've had a similar situation, and the problem that is that you're not matching the existing conditions as you go along, and it throws off the overall look of the property and the development, and that's a concern as a developer. I just want to keep a certain theme.
Thanks.
But
okay. And I did have a question because it was in your testimony that I missed it, and it's really not. It's sort of both planning, architectural, and engineering. That I missed the vinyl fence. So your testimony was that you're taking down the stockade fence and putting up a vinyl fence. So my only question would be with the amount of energy and architectural finesse that went into making this look more of a industrial nature, is it possible to just not use a white vinyl fence? We use dark colored vinyl fence?
If you recall, we had, an interested party who had raised concerns about our application, and our resolution with that interested party was a very specific white vinyl fence that needed to be in between our property and their property, which we have committed to doing. So, and that is went through a lot to get that, quite honestly, in the specific form, and here's the picture, and this is the fence, and this is how high it's going to be. And they liked it, and that's why they're not here. So that, I would.
So their testimony is that.
But no, but let me ask a question then. So that is, this is a very, with a dog leg shaped lot. The amount of light that's going to be out there, especially as you follow through to the east and you're connected to a stockade fence as you go behind American Tire. It's a shopping level.
I agree with you. A white vinyl fence is not going to sit well here. I would have loved even a brown vinyl fence. It's the vinyl that the neighbors.
So let me ask them though, could you put a white vinyl fence that goes around that corner and do the rest in brown?
Again, back to the previous point, the overall picture has to flow. But I can ask the neighbor if he's okay with brown versus white. I'll do that. It's less tacky. No, the brown.
No, I said khaki.
Oh, okay.
Vinyl comes in white, khaki,
whatever.
Brown.
Yeah, it's like a light.
Okay.
Definitely less.
We can work to see if they would agree to change the different colors.
So you've heard a preference expressed on the board, and we can, I don't even know if we want to be condition of approval, but we could move it as a work with the board's professionals on this kind of thing. I mean, we would hate to have you tie up on conditions about color of the fence. Like I think that's a bridge too far, but
They're represented by counsel. I can reach out.
We certainly appreciate the thought and will endeavor to.
I think that's
get it.
Yeah.
Thank you.
All right. And Todd, you were asking a similar question, but you're right. That I was going to ask about a plan to upgrade over time lighting, but there is a concern about the older fixtures and things like that. So
And part of it too is, through my interruption, is if we switch these out for LEDs, we need to redo the analysis of the lighting, and as you're changing them over time, it may work when they're all there, but it may not work. Half of them are there, and so concerns about not meeting the lighting as it changes too.
yeah, I mean, and that's unfortunate. I mean, we're stuck in this moment. So the other question I have is also about from a sustainability element is just making sure I got this right. Did the number of make-ready EV charge stations change as a result of the change in housing units?
It doesn't change as a result of the change in housing units. It only changes based on the parking spaces. Actually, no. Well, it's based on the number of parking spaces required.
Right.
So the changes do result in a change in the number of units, because you go from whatever the parking demand was to what it changed to be.
Right.
So actually the number of required spaces has gone down. The parking requirement went down.
Does that change now that we need 3 more spaces?
It quite possibly might.
We
might need to add an additional.
Okay, so that if that's kind of where I was going with that. So because I know that the parking generation for commercial is obviously different than for residential, and so that's why the relief you're seeking on parking is, up until we made this amendment, was going to not be any relief, and now it's just this minimal number. There's no objection to working with the board's professionals on locating those EV spaces, in an appropriate manner. I know that we had some conversation previously, trying to put them as close to the buildings as we could, but not necessarily clustering them all together, because then you have a usage problem of parking and things like that.
Well, and again, our position on it had been that it's an EV stall, but it's not restricted to an EV. And from a quite frankly, from a cost perspective and development perspective, you want to be able to group them together so you can electrically connect them all.
Right.
You know, if we start spreading.
We're willing to work with the boards.
Yeah, I mean, there's a balance to be struck between clustering them together, but also then it means that from a functional perspective for tenants, you've got all your AV spots in one spot, which may or may not be the right configuration for what works in the.
We're happy to work.
Yeah, I mean, we can-
I think your number is still 35, because you were just a tad over 34, and you already rounded up to 35, and now you're 34.65, so I think you got the
They were
right
there,
number.
okay.
And those get phased in as well, right? They just have to be make ready in the ground.
Right.
And as
You have time periods in which you have to get them up and running. Okay. I mean, you can do them all at once. You're required to do it over a 3-year period, I think it is. I guess 3 years.
One of the questions I raised procedurally more for the board's consideration, whether there's gonna be an assignment, because there needs to be spaces, you know, if a tenant comes in as a unit, far around. Would they be assigned a space, like say you're not restricting on the EV use?
Yeah, we're not.
No, there's no assignment of spaces.
We've had other applicants where it's been more complicated about assignments and things like that, and I think the board has generally been, you know, not wanting to have those things assigned because it creates all sorts of management issues. As long as there's adequate EV.
And I think, you know, the requirement is to provide the EV spaces, and if the owner of the property finds that from a functioning standpoint or a functional standpoint, that assignment is required in the future, part of the leases, they can take that into consideration. But at this point, we prefer not to have any assignment of spaces.
Yeah, I would presume that if I had an EV and people were constantly blocking them, I would be complaining to management that I can't get in, and it becomes a property maintenance management issue that would get corrected in that.
Yeah.
Does that mean that the board is not going to require nor prohibit assigned parking spaces? Is that what? just so I'm
I
clear?
think that's what it feels like, yes. That,
Yes.
We appreciate that.
yeah. We're not dealing with the kind of use we're dealing with here is different than, say, if there was a mix of restaurant, commercial, and residential on site. If you had an office building and other, like, the use proposed is not, it's not an issue. It's in the way that it would be with another kind of things. Other questions from members of the board? Just sure, planning testimony. Any members of the public with questions on planning testimony? Okay, are there any other witnesses or testimony to give?
I have no other witnesses for testimony.
Bob, were there what things in your letter that you needed the engineer to talk about?
Not to talk about, no, it's really, there's a lot of stuff in here for consideration. A lot of this report is repetition of stuff from back in March. Indicated items that were addressed, items that are open for discussion, or again, this is a report to the board for board consideration. So you need to, if there's anything on there, you need to sort through. A lot of what's not here is all related to this updated stormwater assessment. As indicated, they made modifications based on various reasons. We've added impervious coverage for various reasons. The report needs to be regenerated. We don't have the ability, and they're not requesting, if they did, we wouldn't have the ability to grant any relief from stormwater regulations, so they're going to need to comply with that.
Yeah, we understand that, and would request that we're gonna have to meet the stormwater regulations, and we provided as much information that we have right now. But that we're gonna have to meet hopefully as a condition of any approval, Mr. Clerico's approval with respect to that.
There's a number of other items in here, getting approval on the borough and the water and sewer. They've made prior applications based on the former proposal, but this is now a new proposal, so that we should track where we stand with this.
Just to clarify, we did make that application to the water and sewer department on the new plans with the new Form A for phase 1 and phase 2.
But then you changed the plan.
No, this was we made this application.
We'll
and-
talk later. The documentation I saw predated the submission. So maybe you took it into consideration
Okay.
before you did.
I may have sent you the wrong one. I apologize.
Okay,
But we
so-
did-
And there's a number of stuff in here, I guess, what I would just ask, there to be details that need to be added, things that need to be assessed. Documentation that needs to be dotted, undotted i's and uncrossed t's that need to be.
And we agreed to provide that information as a condition of approval.
So if there's no more questions from our professionals or members of the public. Is there any other testimony? Mr. Member?
I don't have any other testimony. I can give you, if you want to open it to the public for any
I
testimony.
am going to open it up if any member of the public
Would like an
wishes.
opportunity just to give a little spiel. but
You
it's
can
not
give a
gonna be
closing
long.
after any public statements. If you wouldn't mind, stop sharing on the
Yeah.
laptop just to make sure I can see. Thank you. So is there any member of the public who wishes to speak for up to 3 minutes? Seeing none, I need a motion, we'll let you do a closing statement and then we'll close the public.
My closing statement is going to be very quick. We really appreciate the time that the board has put into this application, that the board's professionals have put into the application in trying to come up with something that's an improvement upon what the board has already approved previously on this site. You have a developer here, despite what might have happened in the past, who's currently building this site, currently improving it, and has every intention of making this project happen for Flemington Borough. And that hasn't happened in the past on this site. This is something that I think is a benefit to the borough. And we really tried to meet your concerns with respect to the project as much as possible. Mr. Nusser provided detailed testimony with respect to all the variance relief that we've requested and the positive and the negative criteria. I don't think there's any substantial detriment to the public good or substantial impairment to the zone plan and zoning ordinance presented by this application. In fact, what you have before you now is something that is more consistent with what you previously approved. And that rendering right now that was presented this evening, I think is a vast improvement than what we previously submitted to you. And I think we have you to thank for that, because I think it's something that's very attractive for the borough. We would ask for you to grant the D variance relief and the C variance relief and preliminary and final site plan approval as to both phases, conditioned upon all the conditions that we talked about, particularly satisfying Mr. Clerico's correspondence. And, we would like to build it.
Thank you. Can I get a motion to close the public hearing and move towards board discussion?
So moved.
Second?
Second, Samina.
Thank you.
Mr. Cook?
Yes.
Mr. Semino?
Yes.
Mr. Dashna?
Yes.
Mr. Campion?
Yes.
Mr. Levitt?
Yes.
Ms. Weitzman?
Yes. Yes.
Jim, Bill,
Jim?
yes?
Yes,
Yeah, sorry.
So public hearing is closed. I'm gonna go to, our professionals, for any board, things you need to point out to the board for discussion items. So we'll start with Jay.
No further comment.
All right. Bob, we'll go to yours.
No, I summarized that before. You've heard the testimony. A lot of what's in my report reference to we moved to a part of the prior proposal. It's no longer part of the proposal. A lot of it was in the report relates to stormwater, and the rest of the report, a lot of the rest of the report relates to details. The remaining items were really for consideration of the board. So the board, has a thing you want to discuss on those items, we can certainly do that.
I don't have any open items in my report that I feel like that I want to share with share with the board, but I think it's important to remember that this is not a new proposal for this particular property. The site is actually subject to an existing approval for 100 housing. And so that approval remains in place unless the board decides to amend it as part of the application this evening. So I want to make sure for the context that this is an existing site approved for residential that the applicant is proposing to improve and if the board finds that that the application is improved compared to what had previously been proposed, I think that should be part of the board's consideration. I also think there are some master plan policies that are that had recognized the previous approval in our 2022 master plan. I had recommended zoning changes to accommodate that previous approval. And there are a variety of master plan goals and objectives that I cited in my report beginning on page 11 that talked about everything from enhancing the financial sector of the borough to creating opportunities for new residential development. So there are, and I can go through this in like, but I just want to point those out for your record.
Kara, can you please provide for the board kind of a summary of what you've got in terms of conditions and things that we should be considering?
Absolutely. So I went back and looked at the various hearings that we've done in this matter. And as I kind of indicated in the beginning, to Steve and I have to go through, you know, what exhibits may need to be replaced with kind of the same thing for conditions. So I'll go through every single condition that was identified, some of which would carry over and some of which may be replaced with what we've heard today and some of the requirements and some change relief. So I'll go through them slowly. We'll put them on the record and the board incorporate all of them if they're meant to make a motion tonight. And then if there's any that are not particularly applicable as we come to drafting the resolution, we can always make that notation and make that determination at that point. But here's what I've got. Obviously, all of the conditions in all of the board professionals' reports, with the exception of anything that's outlined in the resolution, will need to be complied with. Most specifically, the stormwater management items within Mr. Clerico's report. There will be maintenance of debris removal on site. All affordable housing requirements will need to be complied with, as Beth indicated earlier, not only including number, but also including type of units as well as location and distribution within the buildings. I have future access to lot 1 will remain despite the acquisition of lot 4. I do have a question mark next to that, so that may be something we need to revisit. I had comment.
For a second, so that was that you broke up just half a second. Can you reread that one?
Sure. Potential future access to lot 3.01 will remain despite the acquisition of lot 4. That stays. Okay. I had a condition concerning the wall of the basin to be removed, a guardrail removed, and putting in bollards. This apparently was reflected on A4, which was the site plan exhibit. Again, since new engineering drawings, I don't know if that is a condition that will remain or has been altered in connection with the revised drawings.
The engineer is indicating that it is on the current plan, so it may not, it does need to be conditioned.
Okay. All prior conditions of the approval will continue to be in place. The parking for the commercial space will, well, which may be a little bit different again now, will be, that may just be the retail space now, will be provided by way of signage. Residential spaces will also be provided by way of signage, so it's delineated as to where parking will be. shall be shown on the plans.
We really talked about that and with the elimination of a commercial space in building 2, it wasn't anything that
I think it was
came
more
up.
the signage between the neighboring properties.
Right, it was making sure that the adjacent businesses on the other property didn't use their parking.
It wasn't our intention to say residential parking, store parking on every single spot.
That's obvious with the removal of the one commercial tenant. So how are we gonna rewrite that? It's going to be signage, just so the adjacent property. What exactly are we trying to accomplish there? If you could just say that again for me.
We want to make sure that American Tire or any other properties east do not use the applicant property for parking for those retail and whatever other uses subsequently come into that site. So it was signage, mostly. It's not every parking spot sign. It's more of just some signage that, parking is for tenants.
This lot only, tenants and, commercial and residential tenants of this lot only, something along those lines.
Along those lines, yeah.
Okay, so we can put in something that the applicant will work with the board's professionals to delineate signage, to restrict parking to tenants of the properties only.
Something like that works, yeah.
Okay. That the parking will be included in the leases where they can and cannot park. All ADA compliance requirements will be met with regard to access and parking spaces, etc. I had a condition indicating lighting fixtures to match. I had lantern style fixtures to continue. Beth brought up tonight that the board should discuss whether or not they want to continue the existing fixtures and lighting or transition more into the LEDs that you're more accustomed to doing lately.
And this is a board discussion matter, I think, and so let's put a pin in that one, and when the board starts discussing, we'll see what we want to do on that one.
Okay, that one we already did. Okay, I have amend the sidewalk at the entrance on Broad Street to mirror the property to the south.
There was testimony at a prior hearing about making sure that road, curb, grass, sidewalk match the property.
Yep, street curb, grass, yep, correct, absolutely.
That's been done and it is reflected on those current plans, what the engineer is saying, but so it's a condition.
Subject to review,
Subject to review by the board's engineer. Yeah,
I forgot.
all right.
Okay, this I know will be changed a little bit. I've had no, this should stay. All rooftop units will be within the height requirements and centrally located or screened in accordance with the borough ordinance requirements. Obviously, that's applicable regardless. They're not getting any relief from that now. But one of the things that did change was the calculation of the building to accommodate the parapet, which now brings that height. And that was which building? That's building.
Great.
Which building was that for that we discussed? 1, 2, or 3? 3. Okay, so that one piece of relief will need to be identified as well. So that changed. I had an O&M manual for the green roof, but we don't have that anymore. No resident access to the roof, but now that's that's changing now as well. I have that's covered. I had a question here whether or not the pocket park will be constructed in phase 2 and whether that should be a condition.
Phase two.
Phase two.
Phase two, okay. I've had a speed bump will be installed at the property line with American Tire. And I did have a question mark by that.
Reflected on the plan.
Okay.
As is a speed table at the crosswalk and a speed bump across the entrance by Broad Street. So those,
Okay, but all that is on the plans.
all those conditions are now incorporated on the plan.
Perfect, okay, so that's what we're approving. I had a question, big windows on the second floor, do we want them tinted or change into a 2-story unit? I don't know if that's been changed.
Temporals makes that a moot point.
I'm sorry, again?
The change in the design presented this evening makes that a moot point because they put brick facade to break up that window space. So it's no longer a necessary condition.
Perfect. I think now we're getting into tonight. Obviously, the approval is going to be the latest sets of architectural plans prepared and submitted to the board. The architectural design materials will be as close to existing Spice Factory, specifically brick, awning, railings. The will approve the submitted. The architectural plans will be fine-tuned to reflect what is shown in Exhibit 13. We discussed the utility door needs to be better depicted so it more accurately represents an ADA door as opposed to something that looks like a utility door. ADA accessibility we talked about. There was a lot of discussion with regard to the fencing, the stockade, the vinyl. I'm not neighbor, I have that separate, but Bob was asking some questions regarding who installed it, and I don't know if there was any condition that may have needed to come out of that discussion.
I think it was more, we were having a discussion as to why the fence was oriented the way it was, and the applicant did not provide any testimony one way or another. They didn't have any knowledge as to who put it in and why the shiny flat side was facing the applicant property, which is when that is not normal practice. It might have been the borough on the ball field, but I don't think in any way that it generated a condition.
Okay. The plans will be revised to show the actual calculation of at 58 feet height for building 3. And will also be amended to depict the calculations for the grades, the finished floor elevations, etc. The parking requirements and relief that's required will be amended. The required total based upon the use of the mezzanine as additional square footage is 209. What's provided is 206. And so there is a parking requirement, parking variance for 3 feet that's required. The FAR is actually amending as well to be 0.693. All other relief is as outlined in the board planner's revised report of August 16th. If there is any tree deficiency found during the review of the amended plans, the board professionals will work with the applicant to find alternate places for tree replacements. Otherwise, the applicant will provide the necessary contribution to the borough. The lighting we're going to talk about, all items and reports addressed. The applicant agreed to reduce the lighting illumination as necessary as determined by the board's professionals. The applicant also agreed to discuss the potential for the vinyl fence being constructed with the neighboring to be of a brown color as opposed to white to more fit in the design of the development. The applicant will work with the board professionals to properly locate EV parking spaces. And all stormwater management we have. So that's everything I had.
Okay, so one thing I want to change, Beth's review memo of the board's planner memo of August 16th. On page 6, where there's a summary table of relief required. Just to make sure we understand that the testimony given this night is that building 3 was 58 feet. The proposed height on her table has 64.33 feet. So it's still relief that has to be granted because the standard in HR is 35 feet. But we just want to make sure that they're asking for 58 feet where 35 is the standard.
And I think there are also a couple other changes in that report, in that table. The applicant had testified, and I think it's been determined that they do have the right to access the 70% maximum impervious cover standard in the zone, so there's no impervious cover variance that's being requested or necessary. Also, their FAR increased by a very small amount as a result of incorporating the mezzanine for the salon. It's shown as 0.687 in the report. I believe it was 0.693.
Correct.
Yeah. So that's 6. So again, where 0.20 is the FAR in the HR district, and they're proposing 0.693. The impervious surface, the testimony has been that they are proposing 0.633 and do not need relief because they will satisfy the stormwater ordinances and not be subject to the penalty. And if they don't do that, and then it's a compliance problem. They're not asking for relief on the FAR.
I have one other condition that I didn't hear. The applicant had committed to providing a stone wall along the Broad Street entrance that was compatible with or consistent with the historic stone walls found elsewhere on Broad Street.
It is on the plan.
Details. Yeah. No, there's not a detail provided.
That's, yeah, I know the wall itself is provided or
There's a-
shown.
Yeah, there's a comment in your letter that we worked with you to make sure that it was acceptable.
Okay, thank you.
So
Sorry, it's covered in my.
it's covered in the report, but Kara, if you want to have that, the details of the stone wall, location of which is reflected on the plan, the detail would be conditioned that the applicant will work with the board's planner on the detail of that stone wall to restore consistency with other stone walls on Broad Street.
So Beth, your chart, there's not an impervious surface ratio requirement.
Correct. Yeah, the HR district permits 70%, but then we have an impervious cover standard that says if you don't meet certain stormwater management regulations, you lose access to, if you will, 20 percentage points of your Bennett permit. And that's why this report references the required impervious cover at a maximum of 50%. But now that we have a better understanding of what they're proposing for stormwater management, the maximum permitted is actually 70%.
And the conditions met, which the testimony was given that the conditions were met. And who decides if those conditions are met? Is it a Bob decision?
Yeah.
Well, it's not just a Bob decision. Their testimony is that they will comply with the best management stormwater BMPs. There's some DEP stuff that they've got to get taken care of, and then they've got some Hunterdon counties, to go, and then once those determinations are made, their testimony is that they will comply and not be subject to the 20% penalty.
And more specifically, the ordinance requires that they meet the requirements for a major development under the state stormwater management rules. And then furthermore, that they provide certain stormwater management techniques or use certain stormwater management techniques to address the stormwater management. They've provided multiple of those techniques.
And even if the conditions can't be met, this board can't grant a variance for stormwater management. That's correct.
We can't grant relief for stormwater, but it would mean that there exists the FAR, I'm sorry, the impervious surface that they're proposing is 0.633. Okay, and it meets the 0.7 standard, but it doesn't meet the 0.5 if they fail to use the best practices that the state regs were, have delineated and all the rest. So we can't grant relief from stormwater. What our question is whether or not they're subject to 0.7 or 0.5. Their testimony has been that they will comply with everything they need to do to the satisfaction of our board's engineer and state regs to not trigger the 0.5 and to be within the 0.7, so they don't need a variance on impervious. That's their testimony. That's their application. We have to talk about that because Bob's letter talks about some of this, but that's the.
And what this board is essentially doing by taking that representation, we're not granting the impervious coverage variance. So if for some reason they can't comply with the requirements, even though they're required to by way of the stormwater management rules, if there's any issue and they do have to come back because maybe in order to comply, they have to include more impervious coverage, whatever the case may be. If that representation is not accurate, they'd have to come back and get a variance. But they're kind of so intertwined with each other that it's probably unlikely. In order to comply with one, they'd be entitled to the 20%.
Okay, so are there questions from board members of our professionals?
I think there's one more that hadn't been discussed.
Oh, another condition? Yeah.
Well, we had discussed the screening on building 2 on the roof, where we had requested that be removed. It was part of the prior plan. And I just want to make sure that that's recognized as being part of this plan as well.
It's represented on the submitted plans, correct? So it's not a condition, but but it is something that you're seeking.
We're really seeking, because one of the conditions was compliance with all the prior conditions. I just want to make sure that.
With the exception of that.
With the exception of that.
And all the other things that these other plans
Who is that represented? Was it a prior exhibit or something to represent that? Because we don't have architectural plans. We don't have revised architectural plans.
I think it was either in the resolution or in prior plans, but that.
There was a separate plan that Alan submitted.
It was.
For the sight lines for the equipment on top
Yeah,
of.
but he's talking about the prior. We submitted evidence in this hearing.
No, I think Chris is right. There was an exhibit you submitted as part of that request.
It was in the testimony given in a
It's
prior.
not part of the plans that are before tonight.
Right.
It's an exhibit that's part of the record that you want to bring.
Correct.
Yes.
Yeah.
And it's just that I don't want that condition that says compliance with everything that was granted before.
To not also
recognize that.
Okay, Kara, you follow that?
Yep.
Okay, so that's something we can certainly make sure is in the language of a resolution. Okay. Other questions from members of the board? Or I think we've asked a bunch. We've got to discuss.
That the front yard and side yard setbacks are still the same.
No. The building, it's in my report, this building is a few inches different than what you had before.
2 inches further. I mean,
No, I think
it's not closer, it's further. On the side.
So okay, we can just go through these one by one, just to make sure we got. Minimum lot depth is not an issue because it's 200 feet required and it's 770, so there's no variance. Front yard setback is 35 feet in the zone. Lot 3 is in Beth's table has 17.95. Lot 4 has 24.88.
Existing.
Those are existing non-conforming conditions. And so we are granting relief from 35 feet for existing non-conforming.
That's on building 2.
Building 2, well, now this one says it's a lot 3 and lot 4, so I'm assuming that's building.
It's building 2, yes.
Yeah.
Building 2.
Building 2, which is an existing building which can't be removed. So it's existing non-conforming, so there has to be relief granted. The side yard setback where 25 feet is required. Building 3 is according to this table at 12.53. But the question is, has that changed based on the most recent submission?
It's 12.87.
12.87.
Yes.
So that's a change to Beth's table. Okay, thank you for asking.
And the side yard for building
Is it frozen for anybody else?
Yeah, me too.
Okay.
Good. Well, not good, but.
Two.
I'm gonna let Jeff know we can't hear anything. You are too?
Yeah, sorry. Yeah, I'm texting too.
We're back. We're back.
Okay,
All right.
got it.
Nothing substantive happened, Kara, don't worry.
Okay.
Things went real bad, so don't worry. You know, we have a comedian sitting here on the board. Okay. All right, so that was that. Other questions and discussion from the board?
Before we make a motion.
Well, so the motion, what we need to do is, the one substantive thing we need to talk about is the lighting is the only thing in my notes that needs a discussion. But is there so that we can have discussion, if we, are there other questions? Which that's what I can bring to discussion.
Kind of related but separate condition.
Let's put that into discussion. Or wait. Okay, no, we'll put that into discussion. All right. All right, so is there a motion on the floor?
Sure, I'll make a motion that we approve the, according to my notes, Kara, are the variances outlined in Beth's chart, which are front yard, side yard setback, maximum building height, maximum number of stories, and FAR floor area ratio. You have all those numbers in Beth's chart, and the testimony that we just got to correct those, as well as a parking variance required 209, provided 206.
Yes, the use variance.
And the use variance of residential on the first floor. So I'll make the motion that we.
Actually, it's residential in the entirety thing, because it's HRS.
Oh.
Yep.
The entire.
And preliminary, and I'm assuming we're doing preliminary and final major site plan approval.
Yes.
Yeah.
Amended major site plan approval.
Yeah.
So Todd.
Exactly what I meant to say.
Todd is moving that we grant preliminary and final with that variance relief subject to the conditions that we all just talked about. Is there a second to that? Levin second. So now we have a motion in a second we can discuss. So one item is lighting, and then you had another question about, you said you had something else you want to put up.
It was about the wall.
So
Want to go?
you go first.
Okay. Regarding the proposed wall packs that will be on building 3, I believe. I would like to consider a condition where, I guess, if possible, Beth would, review other better fully shielded, dark sky approved style light fixtures that would match the pattern of lighting, whatever's required there and necessary if possible. Is all I was gonna suggest.
I'm getting a sense that the applicant wouldn't object to that. Okay. All right. So then if we're still thinking about lighting, the question, it's a policy question on the board is, do we have been insisting on LED lights as new developments. That's been something we've been doing for a while now. It's met in terms of meeting a number of sustainability and master plan goals that we've had. And I think that in general, that's been a good policy of our board. The applicant is asking to keep the existing light structures for a couple of reasons. One is the expense of replacing them. Two is the fact that aesthetically, they fit with the existing building and the existing structure, and they were subject to a prior approval. And the third point that Beth raised, which I think is an important one, if you want to pull out all this lighting and stick it in a landfill, is that better than putting it replaced with LEDs? I think Todd and I both wanted to have our cake and eat it too, and be able to see, could we phase it? And I think that we heard testimony that suggested that would be nearly impossible because of foot candle patterns with different kinds of light units. You can't really phase this stuff. It's something that has to kind of happen as a package. So we have to kind of have a discussion as to which, where do we want to go? Do we want to allow them to use the existing lighting structure fixtures as they suggested, which is not consistent with our design standards? Or do we want to insist that they replace them? I don't know. So I'm gonna open this up for discussion because I think it's the one substantive thing that we haven't quite resolved yet. Folks have thoughts.
So just, there are ways to remove the ballast of the high pressure sodium fixture and replace with an LED bulb. I'm not exactly sure as an electrician, I don't know. So I would propose that you could potentially keep the same fixture in the whole configuration and just go to an LED bulb. But the ballast would not come into play. It's not high pressure sodium working. So perhaps the condition could just simply be that a feasibility review is done to see whether or not that's possible. If it is, replace with LED. If not, maybe keep the same fixture then.
Subject to
whether or not it's
professional.
whether or not
Like who gets to say yes or no is I think is the
And
question.
and the only concern I have is I have no idea what the answer to be, but I'm concerned that it's feasible, but it could create issues, either because maybe simply replacing with the LED fixtures to provide like. And I know this is not the board's concern, but just in reference to what the applicant has indicated part of their concern, I don't know what the cost is to make that feasible. I don't know that it would be significant, but I just.
But don't you think sooner or later, those light bulbs that are out there now, just like we can't use incandescents in our house, that sooner or later, they're not gonna be available and they're gonna have to change, no? You're. What? So were incandescent light bulbs 2 years ago.
Well, yeah, but the incandescence was a long phase out. I mean, that was like a decade ago. I found one the other day actually at the house.
So I guess at my point, wouldn't a condition be, I mean, to be sort of a little lighter and to not be so heavy handed to say, it wouldn't be a feasibility study now. I think it would just be, listen, as like, the testimony that was given was, well, listen, you know, if we change in the future and it changes the foot candles and now it doesn't match the plans, how do you make that to say like, that's okay? That's okay. Then if in 5 years, you can't buy that light fixture anymore, or it's unavailable, or you have to order it and it's a 20-week lead time.
Except our goals in the lighting regs are about safety. Right, and so what we care about is not necessarily, well, we care about the technology, but what we really care about is making sure that the light thrown is adequate for safety and security, but not too much to disturb the neighbors, that it dissipates in an appropriate curve away from the fixture and from the, to the neighbors. It's shielded in certain ways. So like.
Which we have now on that.
Which we have right now. So like right now, the approved existing lighting meets our safety, security, neighbor adjacency needs. What it doesn't meet is the sustainability aspects.
What I was proposing is that you would keep the ballast, everything the same. You would have to find an equivalent LED bulb that's equivalent to the high pressure sodium at 250 watts at the same temperature, the same lightness or softness. It may not be possible, but by not replacing the fixture, you should have about the same tone of light. Now, I think the bulbs though could be 5-6 times more expensive at half the electrical, consumption. 100 watt versus 250 watts, essentially what it is. So it's not really in terms of. So it's like $21 a month versus $11 a month per fixture. The cost, the return on investment, it does take a considerable amount of time. Because of a high pressure sodium bulb is $12.
And I also think when we set out our sustainability element and you look at things and you say, I always balance everything that we do with, well, listen, you want to rip out the old, antiquated, you want to put in the new, but here's a situation where we put in the old, I think it was folks on this board that approved the original. I mean, I'm going back to the original site plan, and everybody likes it. Everybody likes the way it looks, and I can't imagine like people saying, why did you rip out all those lights and put in those ugly whatever? So I'm on team leave them alone. I'm on team leave them alone. I mean, this is a policy question. It's not, I want to make sure everyone gets a chance to weigh in. So let me, Jim, do you want to add anything on this light bulb thing?
I think you're just gonna change over time. I mean, sooner or later, like you said, they won't be able to find bulbs to replace the ones that are in place right now.
Hannah, do you want to add anything? She's thinking.
I don't know. I'm kind of caught in between where I think I'm also on Team Todd, where I'm happy with keeping them where they are, but also at the same time, I agree with Jim in that everything is going to phase out eventually. So do you just nip it in the butt now, or do you wait till that happens? You know, and I'm not sure if technology will catch up at some point where it makes it an easier transition to like keep, you know, the fixture you have. I'm more in line with keeping it as it is right now, personally.
Dennis, is there anything you wanted to add on this?
I think new construction should be LED. That should be the new technology.
Mike, do you have anything you want to add on this?
No, I'm good.
Well, I'm torn between, but you have to be honest, just leave it the way it is. Me working in the industry that I'm in, I would say you go with something that's on the new side, so you don't have to worry about taking care of the antiquated system later on, but leave it as is. I don't see an issue with that. So.
And I think that's why some of us wanted the best of both worlds to say this applicant, even though we're not to consider expenses and finances, but the amount of work that has gone into having, you know, the changes of what this board was asking for. It's just, I mean, to draw a line in the sand and say, now I want you to change all the lights. And we need, I'm not even sure we could do that as a condition, because we have to see new foot candles, new.
I would be happy if the board were inclined to say not all light fixtures in place. I think that's something that could be handled as a condition. It would be subject to the board's professional reviewing the lighting plan and confirming light fixtures. It would be a larger condition than many of the ones that Kara reviewed, but I don't think it's outside of the scope of work that the board is assigned to its professional.
Okay.
Is there any information from the applicant about what the lifespan of the old lights is as of this date, or a guess on it?
When they were put in 2002?
Yeah, they were put in about 20 years ago when the first redevelopment of the Spice Factory.
That's what I thought, yeah. And there's probably some of the bulbs that have been replaced since then, but they still of the old type. I think sooner or later, we're all going to be stuck with doing the new ones. So if you were to try to design the new ones to come as close as possible to the old ones now and then do over a period of time when they do replacement, just try to match them all up.
Yeah, I mean, one of the things that I'm open, so here's where I'm coming down on this, is that when LEDs first came out, they were blue, like they were objectively just blue lights. We didn't have anything about range of colors. We had no distinction between soft light and indoor light and true sunlight, and they weren't dimmable or programmable with my little computer. But it took a few years, but they made an advancement, and I suspect that in a few short years, as the technology is getting better and cheaper and smaller, that there will be somebody who says, hey, you've got all of these old school sodium, fixtures in your parking lots, and it's a huge industry of parking lots. Someone's going to figure out what you're suggesting, right? Like
someone's better now.
Yeah, but it's going to be cost better, right?
Well, yeah, I think more cost prohibitive. right? So
Yeah.
it's more of a maintenance issue.
Yeah, at some point, it's gonna be like, if you have this thing here, you can swap it right now, like, just like I can go to the store right now and say, I don't care what wattage is on the LED, if I know that this thing is exactly like my 60-watt incandescent soft white thing that I got from GE or Sylvania back in 1977 or whatever, but like, that now exists in a way that we're not quite there yet with some of these commercial fixtures in the same way. So I'm inclined to leave it only because in time, I think every property owner is gonna upgrade their stuff to be cheaper to run over time. And once the cost becomes efficient, they're gonna want to swap it out because the electric bill is gonna go way down. They'll do the math. I think that'll take care of it, but that's so. Can I get a straw poll on where we are with the light thing? How many folks would want to see, I think Dennis is clearly make them all LED now. I absolutely heard that. Todd is leave it alone, right?
Or if there was some compromise, I don't know enough about lighting to know, like, when, Dennis's point was it's new construction. Well, not all the lights that are out there now. That's not new construction. They're all sitting there now. They all light the parking lot now. They believe they match the neighbors, like that whole area. So I'm certainly not, new construction, yeah, but so is there a way to match? I don't know. I'd rather say if there's a way to make them LED and match and leave the existing ones, sure. If there's a way. But if it changes the foot candles, it changes the throws, it changes the calculations, then I think it's too much. I really do.
Okay, so, yeah, okay, and that's where you're at?
Yeah, maybe it's.
Right, so
I had a thing, would it be crazy to say, like, could you take the light poles down in a way that doesn't damage them so they can be used somewhere else? Is that a crazy thing to say? Is that like going extreme recycling? I don't know, like.
The fact is that what exists now applies with our lighting ordinance. It's really hard for us to enforce a condition because they are complying with the lighting ordinance. So
I'm just curious, so down the road, right, they start burning out, they replace the fixture with an LED. Is it more of more maintenance and enforcement at that point?
Yeah.
So it's off of our.
It's off of us.
So we just don't worry about it.
So
To the extent that they would need to install new light fixtures, if that were necessary, I think at that point, it's probably going to, actually I say that. Probably.
It might trigger minor.
It might trigger minor site plan if they have to. In order to accommodate those light fixtures, so, but I wouldn't count on that.
Okay, so could we could make a condition that, long which we could make a condition that they explore it, but
I don't think it's worth, the more you think about it, because even if you get real close to an LED equivalent, you still have to cost prohibitive, but you still have to make sure that throw is still the same. You gotta make sure that all the lighting plan, it has no impact on lighting plan. You almost have to read your light at that point.
Right, but Jeff, to your point, and I'm trying to balance everything. If they meet our ordinance,
yes,
then what right do we have? Then change our ordinance.
We don't. We don't
have a right to say.
That's where I'm going.
We would really like. We don't have a right to say we really like a brown fence either. But it's something that asks for. It's something that asks for.
All right. So I think that the applicant has heard this discussion. I think we're not going to make it a condition, and I think that the applicant may find a way to be compliant with our ordinance. They might find a way to do this with LEDs. It sounds like they won't, but if they could, great. That seems to be that's what we're seeing. Yeah. All right. Is there any other discussion? Good. So is it no?
No, my only discussion, I'd like to beat a dead horse, going back to the fence. So just from a procedural question. So, it sort of rubbed me the wrong way to say, well, I made a deal with the neighbor and he gave me a picture and that's what we have to do. Or the neighbor be sitting here complaining. That's not the neighbor's right. With all due respect, right? I'm Kara, I guess I'm asking you, like, why couldn't we have a condition? We're at the board that they need approval from. why couldn't we say, you know what, we'd like to not see a white fence? And we're really sorry, neighbor, you can come in and yell at us during the next public comment. I don't know. In other words, it felt very strange to say, oh, but the neighbor gave us a picture. Well, what if the neighbor gave them a different building design and said, but I want you to build this building?
Well, and I certainly think if the neighbor gave a picture or request that was violative of your ordinance, then we wouldn't be having this discussion. I think that what typically happens is applicants work with the board, and if they hear that there's something that the board would prefer, then they do their best to work with them. In this situation, which we've never really had before, there was a third party that was represented by council, that there was a discussion among them where they were able to come to a resolution, and this was the resolution.
I'm sorry, Karen.
Sorry. I think at this point, we can certainly ask the applicant to go have that discussion with the neighbor, and hopefully it comes back in a positive way. I don't know, to be quite honest, if the neighbor weren't even involved and the applicant was proposing a white vinyl fence, I don't necessarily know that we could say, well, we'd rather it be brown. So, I mean, taking the third person out of the mix, I think that's kind of where we are, and hopefully it will all work to everyone's,
Okay. Fine. When the issue was,
action, because the overall project is what we're looking to do.
Can you block people going onto my property and back and forth?
Well, no,
but the fence.
Right, but let me say this, whatever arrangements an applicant makes with adjacent property owners to prevent them from becoming formal objectors is their business. Their business then is to then take whatever agreements and plans that they have, present us with something, and what they presented us with is a white fence, and that's what's in front of us. And we've made it clear that we would prefer another color. They're going to see what they can do about it, but it is not enforceable. Like they are proposing what they are proposing. This is what's on their plans. We have nothing in our ordinance in the HR district that says white fences are prohibited. Like, we don't. It's not a design standard. It's just we are expressing an opinion of the board, and I think that it's been heard. But like, what informs their application in their consultation with neighbors or any app is their own business to do, and then they come to us with whatever plans they have. They chose to put this fence on the application because they wanted to avoid an objector, and that's entirely within their rights to do. But if there was an objector, then we would go through a process of, they were represented by counsel, they would have the right to question and cross-examine, and the MOU covers that, right? We would have done it that way. So like we would adjudicate the plan in front of us. Thank you.
So to close the loop, we're taking that condition out. So I think it was.
Well, the condition just said to reach out.
The condition was to reach out, and I think that's adequate, and they've kind of agreed to have a conversation. Yeah.
So do you want to shift the discussion then to the variances?
We do have to cover that in board discussion.
I mean, because I think Beth put it great to say, this isn't like if you think of, oh, wow, you're putting a lot of houses here. No, we're already putting a lot of houses there. They're already approved for 100 units. So now they're at, I forget, it's either 100, 1,300, 116. So, so that discussion really is not the unit, it's not the amount of units, it's whether or not residential works in this zone, which we would typically not say residential in this zone. But given the fact that they're on the corner, in our own master plan, we were toying with what zone should this fit in. There's first floor residential right to the west, and all the way around the corner. So it's sort of like the gateway, and then there's a graveyard on the other side as you go into town. So, I think from a residential use on the first floor, I think that same reason we granted the variance last time would give, although it was a lot harder last time because they didn't do enough parking. Hence the whole weird design with the raising the building parking. So I think the residential use, thanks Beth for bringing that up, because we've already sort of not set a precedent, but we don't do that, but you know, to say, wow, I can see why residential could work. And then the height, we've already said, right? I mean, that's part of the other application as well, even though it's a new application. And then the parking spaces, we had granted previously, I think 24, 25. Yeah, in the old.
32.
Yeah. Okay, so I'm like north of a dozen.
Yeah.
And we made them, you know, change the building design and just to try to get more parking. And if they brought it down and figured out how to bring it down to only 3, I don't want to say it's de minimis if I'm looking for one of those 3 spots, but it seems really small.
And I will have to add on that, like Jay's parking testimony is that our ordinance, and it's not just our ordinance, the residential side of Sanders over park the hell out of projects. And I do not think anybody's going to be looking for a park, certainly looking for a parking spot. I do not think the granting of this is at all a problem in terms of the park. Anyone have anything else to add on the variance relief being sought? Anyone have any concerns about negative impacts on the zone plan? Anyone want to say anything that it does not further the goals and objectives of our master plan documents?
No, but
I'm trying to think Kara happy and put stuff on.
No, but I think even like the increase in FAR, it's still below what it allows for. The height, we've already had that testimony on the fact that they're lower in grade and you come off of the retirement community or to the west. You know, all of those reasons were why we like this application. I know it's not precedent, but why we like this application last time. Really what I heard from this board was, you know, was more of the design, the aesthetics, way it looks, way it works into the neighborhood. And I think they did a great job at working it into that area. I think you'll be really proud to drive by and see something other than that parking lot, you know, that's there now. So, and I don't think it from a master plan perspective, it fits right into needing more feet on the street, more people downtown. It's a gateway into our community. And it's going to look like an adaptive reuse, even though it's not. We made that clear last time, but it's going to look like it's an adaptive reuse and feel really good coming into the town.
Anybody else want to say anything? Dennis, go ahead.
Yeah, I agree. I think it looks great. I think the changes they made, I think it'll really fit in very nice there. The only other comment I had was on the trees. I hope that they will do all the trees versus paying into a bank, given the size property. But those are my comments. Thanks.
Yes. I think we're done with discussion. I'm going to call the question. So call the roll. This is for preliminary and final site plan, subject to all variance relief as we have already laid out and all of the conditions that we talked about.
Correct.
So from a procedural perspective, Kara, if we're voting on this as a package, the C variances ride with the majority. The D variance, which is residential on the first floor, has to have 5 affirmative votes, correct?
Well, if it's made as one package of a motion, then essentially you need 5 votes in favor to adopt it. You wouldn't bifurcate what you need for the C's versus what you need for the D's. If for some reason you wanted to do that, you certainly could. But if you're doing it as one motion with all the relief that's necessary, you need 5 affirmative votes.
We have 9 members here anyway, so it's 5.
Okay.
It's only 7 are voting. It's only 7. That's right. All right. Call the roll, please.
Mr. Cook?
Yes.
Mr. Levitt?
Yes.
Mr. Joshua?
Yes.
Ms. Weitzman?
Yes.
Mr. Campion?
No.
Mr. Hill?
Yes.
Mr. Stamina?
Yes.
Okay, thank you.
Thank
Thank you, guys.
Appreciate it very much.
Look
And,
forward to getting this thing going.
we do as well.
So wait,
All right, because I know we're already at 10:45 and I want us to be done quickly. We've already kind of mentioned the next meeting, September 12th. We've got 2 public hearings on the schedule. Is there anything else?
And, Striker for 13 Brown Street.
That's it, right?
No, possibly resolution, but, you know,
Resolution, yeah.
I'll put it on as a placeholder. You know.
Good night.
Anything else, chair items?
And then, of course, on October 19th, we have 78 Church Street, and then on the October 3rd, then we have
September
October.
19th. September 19th and then October.
And then October 3rd is Central Lawn Station.
Okay, so you're not gonna be here, Which day?
I'm not here on September 19th. So if we start something on the 12th, just whoever is the next alternate up, I mean, just.
Usually most people are here.
Yeah.
Okay.
The only question I had under chair or two was, Tara, no, we have no update on the circle sign.
Nope, I was gonna do that during attorney reports. I can do it now if you want.
You can do it during the report.
You can do it during attorney reports. And my other question, I mean, I know I sound like a stickler trying to look at these areas in need of redevelopment, but can I at least get a confirmation on this board's requirements? So if you remember, let me just pick the Cornell Square. We had a requirement that there would be monthly meetings, and I think you would attend them. I thought it was that there are monthly meetings that involve neighbors. Is that happening?
I don't believe.
So, but that's my question, like, and I understand the mayor's conversation about some things are our responsibility, some things are the council, but that was our resolution. So I don't understand, like, where does the enforcement? And that's why I'm getting annoyed, obviously.
So for your existing redevelopment, so your approved redevelopment areas with site plan approval, that enforcement, I think is gonna incur via the normal course, which would be probably flagged by your construction official. Since they're gonna be closely watching them.
And I don't remember if it was monthly or not. I thought it was a frequent.
Regular meetings.
Regular meeting.
I don't recall the details. I have met with them as they were getting their application together, doing the resolution compliance, but I can't tell you that there's any sort of regularly scheduled meetings that I personally am involved in. I have to say, I also don't recall how that condition was worded, so I can't tell you off the top of my head whether or not they're in violation of it.
Can you check
Yes.
before next meeting?
I certainly don't want to step on anybody's toes on the council or the mayor's. That is not my intent. My intent is things that we say from a board perspective. Hey, this is what we require, and then they don't get done. So I don't, just trying to follow up on things that we can follow up. That's it.
Thanks. Any other chair items? All right, bills were circulated before the meeting. Susan had one minor thing for Bob, which he's heard. Is there, making a motion to pay the bills, audit bills?
So move stuff.
Second, love it.
Yeah.
Ms. Delegate?
Yes.
Mr. Dashna?
Yes.
Ms. Weitzman?
Yes.
Campion?
Yes.
Mr. Hill?
Yes.
Mr. Mino?
Yes.
Mr. Eckel?
Yes.
Mr. Show?
Yes.
So Kara, professional report, talk about the circle.
All right, so the council for Catalyst that's responsible for development projects, his name is Jack Larkin, Larkin. I spoke with him on August 9th, and he told me that the issue with regard to the plantings was due to the fact that the water that was being used to treat it had salt in it, and that killed the plants. Since that time, they've installed a pump that feeds the water to the tune of about $40,000. That is all done, and apparently they're in the process of getting the plants from a supplier to install the new plants. I spoke with him again today for an update for tonight. He said still working on the plantings. He'll get back to be received, and he also indicated that the display which I'm assuming is the actual billboard display going to show all the advertising, is shipping in the next few weeks. So that's the update that I have. And that's where we are.
Thank you. Anything else? That's the only thing you had, right?
That's the only thing I had. You'll have that premiere resolution with regard to how they're going to replant in the fall and what their bond is going to be. You'll have that for the next meeting.
Thanks, Kara. Bob, do you have anything?
No.
Beth?
No.
Jay?
No.
Do we need to go to executive session?
We don't.
Make a motion to adjourn?
So move go.
All in favor, aye?
Aye.
Aye.
Thanks.
Aye, aye,
everybody.
aye. Yes. Little one.